Testing, testing. This is a test of the Seventh Circuit Court of Appeals. Testing, testing.
Good morning, everyone. Our first case today is WEC versus SFA Holding, Inc., Appeal Number 23-1489. Mr. Docketerman.
May it please the court. Thank you, Your Honor. Good morning. You can call us Sachs as opposed to SFA Holdings. This is a case where there's nothing in the record to reflect why we should be here. Pardon me, I'm still getting used to two sets of glasses. There's nothing in the record to reflect why we should be here. This is a case in which two different plaintiffs want overlapping pieces of my client's
Can I ask you a question about that? And
Please.
Especially with respect to the other plaintiff. Isn't that very easy for us to deal with by just saying in an opinion, we hold him to his representation of the district court, and that's it. That's the end of that issue.
Your Honor, it depends on which him, because you could hold, the way in which this unfolded is, as you look at the complaints, both sides wanted the same money. The him, which is WEC3, the first plaintiff here, said, okay, I'm only looking for certain money now. But one piece that neither one of them has yet abjured is the money that is owed from the time of this judgment forward. And they all want money through rent through January of next year.
But if we accepted that argument, then in every similar case, we'd have to say, oh no, I mean, let's say the lease went another 10 years. Wouldn't we say, well, we every month Saks is not going to pay rent, and we can drag this out for 10 years before there's any judgment that the plaintiff, whoever is the plaintiff, can appeal under Rule 54.
There are two answers to that, Your Honor. The first is that they could have sought a declaratory judgment below, in which case you would have a final disposition and we would know exactly how this works. Both elected not to do so. The second is that if we are correct that the trial court erred on the substantive issues, and I'm more than happy to address the substantive issues, we'd be back here a second time. And that's what the piecemeal litigation argument is all about. There will be serial appeals if this court agrees with us and sends the case back down. That's not what 54B was for.
Can I ask you a question? Oh, I'm sorry. Go ahead.
Yeah, I mean, really following up on the line that Judge Kirsch is pursuing, and I'm going to ask your opponent this too. I think your argument rests very heavily on what I would call the old installment contract rule, that each installment is a new debt, and so at least your opponents are saying that these future rents haven't even come due yet. So what was resolved was a complete case, so to speak. That's what we're looking for in Rule 54B, something that's truly capable of being confined. But I have two questions. One of them is, what, in your view, was Mr. Tully talking about when he said, we are seeking only, quote, consequential, close quote, damages? What do you think he means by consequential damages? And the second is this back and forth that happened at the district court level about whether the proper measure of damages was this liquidated damage clause in the lease, or whether it was the judge says, oh, we don't have to get that complicated, let's just do a simple multiplication. Because as I see it, the liquidated damages clause does, in a sense, accelerate. It says that the way you measure the liquidated damages is the excess of the then present value of the basic rent for the remainder of the demise term. It goes all the way out to the end. So if that's at all in play, I would like to know whether you think it is, and if it isn't, where does that take you?
Let me answer the first question first, Your Honor, and that is I don't know.
You don't know what he meant by consequential
I don't know
damages.
what he meant, but because there's a difference of opinion below on what consequential damages are, which is one of the problems with taking this up in different ways.
So that's not a defined term in the lease. We just have basic rent and additional rent.
That's
in the
correct,
lease.
Your Honor.
Yeah.
So when he talks about consequential damages, I could tell you what the discovery has been below, right? And what they're really talking about is we owned a property, we thought the property was worth X, we lost the tenant, the property is worth Y, the difference between X and Y is a consequential damage. There's
But that
nothing in
doesn't
the-
sound like consequential damages. I hate to go all the way back to Hadley against Baxendale, but it doesn't sound like that kind of, for want of a nail, the kingdom was lost, consequential damages.
That's why I can't really answer your first question, because there is a clear difference of opinion on this. One of the problems below, as is evident in the record, is that there was no discovery with respect to this plaintiff. There are 6 cases, as the record reflects, all of which were brought after the bankruptcy of Carson's. Profits bought Carson's. Carson's became the landlord. The landlords wanted the guarantee of the parent. Not at all an unusual circumstance. What is a little bit unusual here is each of the different plaintiffs here was a family office, and so each one of them thought they were getting a wonderful investment. I bought a piece of property. I have a tenant in that property. I'm sending the rent money directly from the tenant to the bank, and I'm fine. All I do is I take the difference, or I take the depreciation, whatever tax benefit there was. And then Bonton filed for bankruptcy, and Carson's stopped paying. So there are a number of different...
Well, and eventually Carson's repudiates the lease.
Exactly, rejects the
on.
lease.
Yeah.
That's exactly
Yeah.
right. Different way in each way. In the state, 3 of these cases are in state court, 3 of these cases are in federal court, 2 in front of the district judge who had this case.
But if I'm correct, we're the first appellate court to actually look at this guarantee and this issue, right?
That is correct, Your Honor.
Okay.
The guarantees are all a little different, but generally they're the same. So it's fair to say that we're looking at the same issues. In each of the state court cases, we've now tried the mitigation issue. We've tried including what is a consequential damage, what are the damages that people have. And one of the things that we have learned in those cases is that the steps that people took in order to mitigate their damages, the damages that they claim, and the way, because this is not the only case in which there's been some effort to divide the proceeds of this deal. The steps that they took altered the risk of the guarantor. One of the errors below, if I may move to substance for a moment and then come back to procedure, one of the errors below is not allowing us to explore that at all. The district judge refused to let us look at anything, refused to let us try anything, and I can tell you that that's why I can't answer your question on consequential damages, because we don't know and didn't know what it was. The rush to this judgment, this partial judgment below, deprived us of the opportunity to assert a number of things which the district court just flat got wrong. And if we're right about that, Judge Kirsch, I come back to your initial question, which is if we go back down below, then we have had this appeal unnecessarily. All of that should have been fleshed out.
So, I mean, I had exactly Judge Kirsch's original question. If you said, we're going to hold you to what you said, true, they didn't amend the pleadings, which you pointed out, but it seemed to me what they're now trying to do is say basic rent as defined in the lease up to the final time point, whatever it was, January 2022 or something like that, whatever it was, is now resolved. That can never come back. There's going to be no duplicate call on the guarantee. And if we say that's that, then I don't see how people can back and fill. Now, if it's not so clear, if the consequential damages that are being reserved include part of this, and I also would note that the basic rent in the lease itself is defined in a particular way. Additional rent is defined, and then it says tenant will also pay the beneficiary as additional rent interest at the default rate on overdue installments of the basic rent. So there may be overlaps.
There
and
is,
if there
Your Honor.
are, then that's troublesome.
There is, Your Honor, and that's a point that we've tried to make below and we've tried to make in the record here.
That the stipulation didn't at least clearly enough. Maybe it's a question of clarity. I don't know.
Well, it isn't even really a stipulation, Your Honor. It's a representation that was made that the district court accepted. But the acceptance of a representation isn't necessarily the litigation position to which they will be held. Now, if this court were to say, to pick up the hypothetical, if this court were to say, we will hold you to that, and therefore you have a separable judgment on rent up until now, that doesn't solve the problem of, okay, then am I going to bring another suit for February of 2022 and another suit for March of 2022 or April of 2022, which in theory, because of the argument that's been made by my friends on the other side, they could do. But the declaratory judgment is the proper way of dealing with that. And when these cases get brought, it's how you achieve finality.
Is it the only way to do it, though? Do they have to seek a declaratory judgment to get a Rule 54 ruling in this case?
If you want to uphold all of the other principles of Rule 54, the answer would be yes, Your Honor. Because otherwise, if I may,
Yes, go ahead.
Otherwise you'll have a circumstance where you continue to deal with new circumstances that arguably could alter the issue of February's rent or March's rent.
No doubt about that. It could alter the issues, right? I mean, the duty to mitigate is certainly different in month 1 of a breached lease than it is in month
Right.
36, right? So you have the estoppel effect, right, of whatever the district judge decided with respect to the earlier months is going to be at least the rule of the case with respect to the later months. Now, the district judge is going to have to deal with mitigation differently maybe every month. I mean, maybe that's the reason a lot of these cases settle, right? You don't go month to month to month to month to month. But I'm just wondering if declaratory judgment is the only way to do it.
Well, may I say it's the best way? It's certainly the cleanest way, and for purposes of finality, it's the only way. There are different ways in these cases.
Well, if you'd also gone the liquidated damages route, unless I'm misreading the lease, that also accelerates all the way to the end. If it takes you all the way out to the additional rent, the basic rent, additional rent, other sums for the remainder of the demise term, that sounds like all the way out to the end.
And if you look at the original motion for partial summary judgment that was filed by Stratford below, they did prefer that. There are issues with liquidated damages in this case that would have been briefed, and I suspect, although the trial court did not articulate the reasoning behind this, but rejecting that argument and moving instead to this argument, the trial court didn't give us an indication of what it was thinking, which is not the problem with this record. And so the liquidated damages issue was set aside. Liquidated damages would not necessarily be appropriate here under Illinois law. There have been arguments about liquidated damages and acceleration in some of the other cases, not that that is necessarily binding here, but it does suggest the misreading of Illinois law on what mitigation is. And the liquidated damages provision here could very well operate as a penalty. And even though it's a uniform guarantee that was used in a lot of places in a lot of different states, in Illinois there are specific rules about this, as the court is well aware. And therefore, that may be why the trial court opted to do this. But that's just another one of the problems with the record that this court is facing. The trial court did not articulate why this case needs to go up now, other than saying, I think these facts are different from the facts that bear on the other case in front of me.
Mr. Dockerman, I want to ask you a practical question
Please.
regarding the consequential damages and the representation below. Let's just say, for the sake of argument, we remand this case on the mitigation, okay? And mitigation particularly, I think it's your position, and I'm sure the appellees will comment on this, but I think it's your position that once the appellees took possession of the property, at least, I know your position is before that, okay? Yes. But at least once they took possession of the property, they had a duty to mitigate. And the district judge allowed absolutely no discovery on that question.
Exactly.
And it basically eliminated the duty to mitigate.
Exactly.
If we were to remand the case on that ground, we would vacate the district court summary judgment order. But then it would be easy for us to send it back for, I guess if we find for you on the multiple parties, right, it would be easy for us to remand and say, and oh, by the way, when it goes back to the district court, you should determine is there really a second party here as to these damages. But then we're only opening the door for discovery in a very little way, right? Which
Yes
should
and
be
no.
fast. I mean, you're going to do mitigation discovery for a short period of time, and then you're going to be right back up here.
The answer to that is yes and no, as in so many legal questions, right? Yes, it could be short that way, but one of the things that we don't know, if Stratford is the successor to WEC3, And it's willing to take on the issue of mitigation throughout the entire period of time, because that's a door that's open with WEC3 right now, right? And so if they're saying this was my mitigation issue at this point, you also bump into the Illinois law on what the risk of a guarantor is. One of the difficulties in each of these cases has been Illinois law is black letter, that if you change the risk of the guarantor, the guarantee is released. And when you change the incentives that the owner has of the property in order to try to mitigate, you actually change the risk of the guarantor, and we have decisions in Illinois courts to that effect. So if it turns out that the risk change, the steps taken or not taken by Stratford to mitigate after they bought the property, and whether they accept the idea that theirs is only from the period forward, when in fact, they have a judgment that goes back to day one.
Right,
Right. So have they also bought the duty to mitigate there as well? That's the no part of my answer, Your Honor, and that's why it's complicated. This is what needs to get sorted out. This is what has been sorted out in other cases like this, but didn't get sorted out below because of the straight path the district court took to try to dispose of part of this case. I'm going to speculate, maybe because the court thought, once I do that, this case will resolve. It didn't, and one of the reasons it didn't is because we still don't know issues of consequential damages, what the overlap is, what kind of mitigation was done. I think the court is aware that having tried this case 3 times, there are 3 very, very different results from the 3 different trials, ranging from $19,000 in one case to several $1 million in another. Why? Because these are such fact-intensive inquiries. And
So, Mr. Dockerman, is anything going on at this point in the district court?
we're in discovery with WEC3.
So the WEC3 part
Right.
is moving along.
It is moving along, but one of the issues is what records are there that Stratford has? Stratford now treats itself as a third party, and it is no longer subject to the same kind of discovery that a party would be. Another one of the evils of prematurely certifying this case under 54B. And I want to come back to both observations.
And Stratford eventually comes in under intervention of right, isn't that correct?
That's correct.
Yeah.
That's correct. And so they're both here saying, I've got a piece of this, and they agreed to divide it up. But I'm not sure we're bound by that agreement. I'm not sure the law supports that agreement. It's one of the things that we're having difficulty exploring, and the reason we're having difficulty exploring it is because I only have one of the parties down there at this point. And that's another one of the issues that arises in this case. You have to understand, working backwards, what the law is protecting guarantors and how the risk applies to that, what the law is with regard to the way in which this mitigation was done, how it was done by WEC3, how it was done by Stratford, what the overlap was. There's the complicating factor of a receiver, and the receiver spills over into both of those places. All of that is the kind of thing that we should have had the opportunity to explore. And it is the premature certification and removal of all of that that frankly hampers us in the way in which we are litigating the remaining case below. So to go back to the initial question, could you say, look, we're going to hold them to their representation? Well, you could do that, but that still doesn't satisfy the principles underlying Rule 54B.
But can I interject? Maybe this is a merits question and beyond 54B, probably is. But one of the things that the district court thought was that under this particular guarantee, you waived all defenses, actually, certainly including mitigation.
Trial court got that wrong. Trial court got that wrong.
I need more than that.
No, and let me explain. Let me explain why. The unconditional language that is used here, and this is not the first time that the courts of Illinois, or at least federal courts in Illinois, have considered this, understands what that means. That means we don't make you go after the tenant first, fail with the tenant, and then come after us. You step into their shoes. That's why twice in this guarantee, we are not only called a guarantor, but we are also called a surety, because the surety is responsible for the performance, the guarantor for the non-payment. And the district court made an assumption and construed the language of the guarantee in a way that's inconsistent with Illinois law and with the way in which it has been construed in the other cases that have been tried.
Right, but the language I'm looking at, tenant's liability, tenant, you say you stand in the shoes
We
of
stand
the
in the
tenant.
shoes of the tenant, correct.
Tenant's liability and obligation hereunder shall be absolute and unconditional and shall not be subject, I'm eliding a little bit, to any defense as a result of a bunch of things, including bankruptcy, without limitation, blah, blah, blah. It's pretty broad language.
It is. There are exceptions. If you're looking at the second page of the guarantee and you go to the third page of the guarantee, there's an exception to Clause F. On certain assignments, there are other things that can be done. The language is there in order to allow the landlord to come after us, but it doesn't remove our ability to assert the defenses of the tenant. The landlord doesn't
So
suddenly...
you say the defenses of the tenant flow through to you.
That's correct,
But
Your Honor.
if the tenant has lost its defenses, then you didn't receive anything in that flow through.
That's absolutely correct, Your Honor. We don't have anything superior to the tenant, but we also are not inferior to the tenant, and an error below was to conclude that we are inferior to the tenant. That's just not Illinois law, and we'll cover it in our briefs. I am now at the point where I have reserved time, unless the court has questions right now.
That's fine, go ahead, you can reserve the rest of your time.
Thank you very much.
And Mr. Procida.
May it please the court, let me take just a moment to say at the outset how pleased I am to be appearing in person in a suit in a courtroom. There are so few courts that have resumed in-person hearings, and it's a disappointment to me because I think this is the most enjoyable part of the practice, and I think things go better when we all get together. That said, Your Honor, let me first address the rush to judgment here. I would like to point out that February...
By which do you mean first address 54B? Because that's definitely what I'm interested in.
Okay, well, and of course, my interests coincide with the panel's interests, so we can go straight to that. My concern on that point is when we talk about a rush to judgment here, February 13th will be the 6th anniversary of the first demand letter served on Sachs.
But that doesn't matter. I mean, as you well know, in order to have a 54B carve out, say the judgment is final this far, you have to have resolved either all claims against a certain party or, everybody's claims, all claims are all parties. So the issue that I'm having trouble with here is playing through these scenarios and saying, what if it's upheld, what if it's reversed, and finding that distinction, because this court, at least, does not always take the district judge's word for it on the first element of that 54B, the separateness element. I don't think, at least I'll speak personally, I'm not that worried about the fairness. Is it just, is it appropriate to take this separately? That's a second and independent element under 54B. But it's the first one. Is it really separate enough to override the final judgment rule? There are many, a litigant in a complex case that wishes we didn't have the final judgment rule, but we do, and so sometimes you do have to wait 5 or 6 years to get all claims of all parties resolved.
Yes, Your Honor. My client's claim, as embodied in this judgment, is limited to basic rent and the prejudgment insurance which has accrued. That's it. And it's
So what were these consequential damages that somebody else is pursuing?
I'm glad you asked that, Your Honor. I would encourage the court...
It's not a defined term.
No, it is not a defined term in any of the contracts. However, in WEC's 56.1 Statement of Undisputed Facts that they submitted in connection with their motion for partial summary judgment, they do define what the consequential damages are that they are seeking, and they are limited to their own attorney's fees and the lost value of the property that they incurred as a result of losing the property to foreclosure. They have no overlap with the basic rent, just as WEC's counsel represented to the court at the hearing on the 56 or on the Rule 54 certification. I would further observe that having made that representation to the court, and I know my colleagues representing Sachs take a view about whether or not that representation is something they can be held to, having made that representation to the court, and given that the district court then adopted that representation as part of ruling on my motion for a Rule 54 certification, as I see it, that's textbook judicial estoppel. To the extent that they may be backtracking or attempting to obscure their position on that issue, I would encourage Sachs to make a motion to the district court to dismiss any claim based on that. But the fact that they are now, if it is the case, attempting to obscure that issue in no way changes the fact that it is a final judgment on my part and that they've represented to the court that whatever their claims are, they have no overlap with the judgment that was issued to me and my client by the district court.
Well, there's a fair amount of factual overlap, right? Like when did things happen and what was the value of the property as a result of the foreclosure and, you know.
Well, I respectfully, Your Honor, I don't think there is. The judgment that was issued to my client is simply the number of months times the basic rent. That's it. And
So no additional rent.
No.
Additional rent is defined in section 4, right?
Correct. And we have.
And additional rent does include interest at the default rate on all overdue installments of basic rent. So that takes you back into basic rent. And also, it's a pretty broad language, you know, all amounts, liabilities, and obligations which tenant assumes or agrees to pay. I'm just looking one way. I find that kind of vague about whether this loss of value claim that you're asserting is anything encompassed in this, or is it not?
I don't believe it is, Your Honor. Their point, and you can see it in the record at ECF 128 in paragraphs 52 and 53, the point being made by WEC on the issue of lost value is simply that this property would not have gone into foreclosure but for Sachs's failure to observe and honor their guarantee. And therefore, whatever the value of that property was when it was lost to foreclosure is a consequential damage that was incurred as a consequence of Sachs's failure to honor the guarantee.
And so if we, hypothetically, you know, if on the merits, suppose we agreed 54B, but if on the merits we were to think that Sachs didn't breach any responsibility under this, wouldn't that unravel the whole structure that you're putting together? In other words, we can't have appellate jurisdiction if it comes out one way and no appellate jurisdiction if it comes out the other way.
No, but Your Honor, I would suggest that the construct you're offering there would remove essentially any 54B certification. There can always be different appellate decisions.
No, not if it's a genuinely separate claim, or literally everything against one particular party has been resolved. I mean, there are 54B isn't supposed to be a gaping exception to the final judgment rule. It's supposed to be an efficient way of resolving things that really are truly separate when you've got multi-party, multi-claim litigation.
Of course, Your Honor. However, I mean, given the simplicity of what is included in our claim, and you know, what I would contend, Your Honor, is the unconditional nature of Sachs's guarantee.
And everybody's waived the right to go against Sachs for additional rent?
No, Your Honor. You need to, I would ask the court to keep in mind the distinction here between, and the operative date here is September 30th, 2022. That's when the judgment runs up through.
Right.
Now, and the court is undoubtedly aware that my approach in the summary judgment papers was to utilize the liquidated damages formula precisely to avoid some of these questions. However, having been presented with...
The court decided it didn't want to do it that way.
Once Judge Leinenweber took this approach, we deemed it the most efficient way to deal with our part of the litigation to then waive claims that had not been decided by Judge Leinenweber's motion in order to seek the Rule 54B judgment. I don't see that remanding on that point is going to lead to any greater efficiency, simply because, well, first of all, I mean, having been presented with Judge Leinenweber's treatment of this as an installment contract, to Judge Kirsch's point, you know, we'd be creating a paradigm where one could never recover on an installment contract until the final installment was past due, and that...
Which was the common law approach, by the way. I mean, you know, Judge Kirsch is pointing out that it's very inefficient, but it was, in fact, the common law approach. And if you look at things like the restatement of the law of judgments, you see that that's precisely what it was. That was the scope of a claim, each installment.
And so, look, I would say, Your Honor, if the court concludes that the guarantee is for some reason invalid and that Sachs didn't violate it, well, then of course remand is going to lead to a lot of overlapping issues. However, if the court concludes the guarantee is valid, all that does is enhance the efficiency of the remaining case before the court, because now the district court will have guidance going forward on whatever remaining claims there are, which I still contend have no overlap with the portion of the claim that was embodied in our judgment.
Can I ask you to address the mitigation issue here, particularly once Stratford took possession of the property? It seems, is appellant just wrong? Is Sachs just wrong that there was discovery on this issue, or that there's a duty to mitigate once at least, forget the time that there was a receiver, just once Stratford takes possession of the property, why is there no duty to mitigate, and why should there not be discovery on that issue?
Okay, several points on that, Your Honor. First and foremost, I think much of the litigation on the mitigation issue has served simply to complicate and confuse what should not be a very complicated issue under the language of this guarantee. Sachs gave an unconditional guarantee of a lease. The tenant rejected the lease in bankruptcy, and Sachs' guarantee waives any defense resulting from the rejection of the lease in bankruptcy. So that by itself, Your Honor, we would contend eliminates any duty to mitigate that would have otherwise attached to this.
Although in the course of answering Judge Kearse's question, can you address Mr. Doctorman's point? He differentiates between the defenses the tenant would retain and not retain, his answer just now on the waiver question.
Oh, yes, Your Honor. And I think the Seventh Circuit's recent decision in Hovde is instructive on this point. And that's a case that both litigants have cited it extensively in their briefs. The point there is that Hovde made a distinction between guarantees being absolute and unconditional for purposes of whether or not a party seeking to enforce the guarantee must first proceed against the underlying obligor, the tenant in this case. However, if you read the guarantee language that is at issue in this case, there's two different introductory clauses to the list of waived defenses. The first says that the guarantee is absolute and unconditional regardless. The second goes on to say, and this is a critical distinction from the guarantee that was at issue in Hovde, that the guarantor shall have no defense for any basis resulting from, and then it has a list of causes, and included among those are both rejection of the lease in bankruptcy, as well as the tenant's abandonment or termination of the lease. And so we would, look, it's our position, and it's no secret from the papers, that if you read that guarantee and compare it to the guarantee in Hovde, you'll see that there's a clear demarcation between why the court in Hovde didn't deem the guarantee in that case to be a waiver of the particular defense being asserted in that case, and why it's completely different in this case.
And just to finish the thought, your position would be, since it's waived, nobody needs to worry about discovery.
Yes, in the first instance, Your Honor, I would say that is our position, that the language of this guarantee clearly waives any obligation that there would be to mitigate, that the duty to mitigate in this case was specifically and directly, to the extent it exists at all, as a result of the tenant's rejection of the lease in bankruptcy. And that's a waiver.
Isn't it prior to that? I mean, it's just a duty under Illinois law. It didn't arise because it's not like you didn't put it in your bankruptcy schedule. It doesn't arise out of the bankruptcy law, and it doesn't really arise out of the rejection. It's just an underlying feature of Illinois law of contract and leases.
Your Honor, the existence of the law is certainly a feature of Illinois law, but to the extent that it has any application in this case, that resulted directly from the tenant's rejection of the lease in bankruptcy. If the tenant doesn't reject the lease in bankruptcy and either the tenant pays or Sachs honors its guarantee, then we're not talking about any obligation to mitigate here. So I do think it is as a result of the rejection of the lease in bankruptcy. And to the extent that the court looked at it differently and thought that bankruptcy was not part of this, the tenant's default under the lease is also specifically listed among the causes that are waived in terms of whether or not the guarantor can assert defenses. So yes, Your Honor, our first position is that the language of the guarantee waives any obligation that may have existed to mitigate. Secondly, Your Honor, the obligation to mitigate here, to the extent it exists, is all premised on a statute that speaks exclusively to landlords and lessees. Now, there's no question that there are a number of cases out there in Illinois law that have extended the obligation to cases involving guarantors. But there's very little jurisprudence out there concerning whether or not it should run upstream in the other direction to mortgagees. And to Judge Kirsch's point in question, once the mortgagee, in this case, my client, took possession of the property, that is extremely removed in both substance and time from the point at which the lease had been rejected. And so what you're really dealing with there now is saying that you have a party that is, because at that point it is not merely a mortgagee, but a third party, well, it's not a third party, but a purchaser at a mortgage foreclosure sale. Mm-hmm. And so we're taking a statute directed to landlords and now saying that applies through the mortgagee to the subsequent owner of the property at a foreclosure sale. And that's a very distant extension of a legislative act, in my view.
It reminds me of questions of privity, basically. You know, do you trace it back that far?
Right. I would also point out, Your Honor, that to the extent that the argument here is that the mortgagee's obligation to mitigate flows through the landlord here has its obligation to mitigate cut off by the foreclosure. And so to the extent that the mortgagee is simply assuming the landlord's obligation to mitigate, the landlord no longer has an obligation to mitigate under the language of this lease once the mortgagee exercises its rights. So I don't see that there can be a continuation of that right to the mortgagee on the basis of that sort of theory.
Are you pointing to this clause, tenant agrees that landlord's duty to relet under section 22 shall be limited and subject by the right of mortgagee to exercise its rights under the mortgage?
Yes, Your Honor.
That seems vague to me. The exercise of such rights being an event over which the landlord has no control. Why does that mean no subsequent owner has a duty to mitigate? Why is it just that if a receiver is appointed, as here, the original owner has no duty to mitigate?
Well, the subsequent owners, Your Honor, would not be a landlord. They'd never be in a landlord-tenant relationship with the tenant in this case, or by extension with Sachs as guarantor. At that point, following Your Honor's logic, you could arguably say that a third-party purchaser at a foreclosure sale would then somehow assume that duty. Okay. To me, the purpose of that language there, and I recognize it's not a model of clarity, is because it needs to be recognized as a practical matter that once a mortgagee begins to exercise foreclosure remedies, that the ability of any particular party to actually exercise what needs to be done in order to mitigate damage starts to become very much more complicated.
Let me take in a different direction. Mr. Dochterman referenced how many cases we have here involving these parties and in this circumstance. Of course, we're not bound by what any district court has done, but should we at all be concerned that Judge Valderrama in the district court ruled in a different way and didn't find the waiver to be a barrier at all in the way that you're arguing?
Well, Your Honor, I would say that it is important for this court to look at Judge Valderrama's decision, look at what Judge Leinenweber has done, and in particular review the Hovde decision, because Hovde was based in large measure on the cases cited by Judge Valderrama, and consider for itself if the plain language of these waivers result in a waiver of the duty to mitigate to the extent one exists. So the answer is Your Honor should be concerned with what any district court in this district has done in looking at these, but I think the plain language of this guarantee in light of this court's ruling in Hovde is persuasive and perhaps dispositive.
So it was Stratford who moved for the appointment of the receiver, right?
It was, Your Honor.
And so, does that in any way undermine the idea that the appointment of the receiver prevented Sachs from mitigating? I mean, you wanted the substitution.
Right, and I believe Your Honor means WEC, the former owner?
Well, the receiver to manage WC's assets.
Okay,
So
yes, well,
yeah.
no, I don't believe it does, Your Honor. I mean, to my reading and my way of viewing the world here, Sachs, well, putting Sachs aside for a moment, my client, as a foreclosing mortgagee, in moving to have a receiver appointed, first and foremost, that is an act of mitigation because the receiver is charged by law with preserving the property. And more to the point, Your Honor.
So you think the receiver would have had no power to mitigate?
No, the receiver was fully empowered to, and really, that's the heart of the matter, Your Honor. We have a receiver here who's charged by law and by the
Right.
order appointing him as an agent of the court with preserving the property. And so at that point, anybody who has an issue with what the receiver's doing, their obligation is to take that up with the circuit court.
Go to the circuit court of DuPage County, All right.
Well, I don't want to waste the court's time just reading my brief back to you. If you have any other questions, I'd be happy to have an opportunity to address them. And otherwise, I'll take my leave and thank the court again for taking time to hear us today.
Thank you, Mr. Procida. Mr. Dockerman.
Thank you very much, Your Honor. May I begin by noting that when you have a piece of property and you have a tenant in that piece of property, it really doesn't make any difference whether the landlord is A or B or C. If there's a landlord who's trying to enforce a lease against Sachs, and they have a duty to mitigate if Sachs leaves. And the same thing was true as if Carson's left, or anybody else who's a tenant. Illinois law is very clear on that. Snyder versus Ambrose, which is in our briefs, makes it clear that not requiring evidence, let alone proof, regarding the plaintiff's mitigation of damages was prejudicial error. And that's not a place that we ever got to. The suggestion made by Stratford that because there's a mortgagee doesn't relieve the mortgagee of the duty to try to mitigate. And if the mortgagee had relet the premises so that there was a tenant in place for all but 5 months, my client's responsibility is for those 5 months. You don't get to double dip. I get the credit for all of that. So the fact that there is a receiver, the fact that there is a mortgagee, that doesn't change things, as the court pointed out. It only means that the preceding landlord doesn't have that responsibility, but it doesn't relieve the landlord of that responsibility. There's a very good summary of all of the Illinois law on this in Lyon Financial Services against Bella Medica by Judge Valderrama. I'm sorry, by Judge Duryagian. It's at 738 F sub 2nd 856, and that's also in the parties' briefs. And it goes through the risk associated with the guarantor that comes from mitigation. And all of that got set aside by the trial court. And the reason that it got set aside was because the court was moving forward. Now, to the question that you asked, Judge Wood, about whether or not anybody could be held to something, the idea that there was a statement that was made by WEC3 in its motion for partial summary judgment about what it was and what that pleading was stricken. And the striking is at ECF 137. It's not in the record. Since that time, WEC has amended to say that it's specifically seeking rent going forward, and it's specifically seeking these other damages, going back to the original question of what were consequential damages. So however you look at this, and whether it's Judge Valderrama's interpretation or Judge Otto's interpretation or Judge Hayes' interpretation or Judge Kubasiak's interpretation, all of whom have cases, or Judge Leinenweber's interpretation, it's driven by facts. And the error in this case was to ignore all of the facts, particularly with respect to Stratford, and then to allow Stratford to come straight to this court without allowing us a defense. In each of the cases that we've tried in the Illinois state courts, there is a finding of liability against Sachs. The trial has been on mitigation and what has been done. And who has that duty and when it obtains is exactly the problem that we've explored in discovery. So this is a bad set of building blocks leading to an improvident appeal. And the improvidence of the appeal is exactly why 54B is used sparingly, not the gaping hole, as the court said, that this would create if you take this. And finding a stopgap, putting a Band-Aid on that hole, doesn't solve the problem and sets a very dangerous precedent. I just want to take a minute to address the Hovde case as well. This court did review the language in Hovde, but it's a bit of a circular argument because you relied upon the analysis that Judge Leinenweber did to say, okay, that's how we're going to interpret the guarantee. And now, even though that was an incomplete record, and it's being used again, and so it becomes something that has much more meaning than, frankly, it deserves. God bless you.
Thank you.
Looking at the guarantee, understanding the facts having to do with the guarantee, and concluding how the parties are bound and what their duties of mitigation were is what's to happen in the district court. It is improvidently here. We should all be back in the district court for a determination of all of these issues. And on remand, we respectfully ask this court to direct the trial court, the district court, to open discovery and allow us to explore the issues of mitigation. You know, what happens to a guarantor, whether it's a guarantor or a surety, not just to make assumptions about that, the way that Illinois courts would do. Thank you very much.
Thank you, Mr. Dockerman. And the case will be taken under advisement. All right, next case today is Scott versus Dart, appeal number 23-1312.
Good morning, Your Honors, and may it please the court. This is an appeal in a case where the defendants argue that the court doesn't have jurisdiction, so that probably should be the first question we get to. The district court refused to allow the case to proceed as a class action. The individual plaintiffs then resolved their individual claims. Mr. Scott accepted an offer of judgment. Mr. Scott's the appellant here. Mr. Scott accepted the offer of judgment, which was drafted by the defendant to carefully follow the instructions this court has provided about how to appeal an adverse class ruling without going to trial, with allowing a settlement of the individual claims. The language that was in the offer of judgment that Mr. Scott accepted specifically invoked Pastor versus State Farm and Espenscheid, which is the cases which allow or recognize or set out the procedure that we followed. The defendants argue that Espenscheid is based on the theory that the named plaintiff may in the future be entitled to an incentive award, and since Mr. Scott is locked up in a jail cell, he can't provide any assistance. It would never be entitled to an incentive award. The problem with that argument is that it's inconsistent with the record.
So what exactly is the evidence that Mr. Scott is entitled to an incentive award? Because I got the jail issue. I understand that. I understand it. But what evidence is there that he has some injury in fact, that he actually did anything here to which would entitle him to an incentive award?
Well, the defendants agreed when they drafted the offer of judgment that Mr. Bullock was entitled to seek an incentive award.
Right, but they didn't, they didn't agree, though, that he was entitled to an incentive award or that he did anything to earn an incentive award. In other words, I understand that argument, but the defendants cannot agree. I mean, if we allowed standing based upon the parties' agreement that the Court of Appeals had standing, a lot of parties would agree that we have standing and seek an opinion from us instead of sending things back to the district. That happens all the time, I assume.
The problem with that approach is that the court accepted exactly what we did here in Pastor and Espenshee.
But you're talking about the district court, right? Or
No, I'm talking about the Federal Court of
Okay.
Appeals. This court, in the case called Wright versus City of Calumet City, 848 F3rd 814, the court, in that case, the offer of judgment did not include this language. And the court said, if you had included the language, we would have jurisdiction to decide the class case. You did not include the language, and therefore, we're dismissing the appeal. We don't have
Can
jurisdiction.
I also note that just as a matter of law, as I understand it, the class representative is assuming the risk of paying the defendant's costs for the litigation should the case be unsuccessful. So there is definitely a monetary stake on the table there.
That's correct.
And you also mentioned your brief, and I guess maybe you can give us whatever further information there may be, that as a matter of fact, Mr. Scott has devoted time with counsel related to this case.
He has devoted time. It's often important for an attorney doing these kinds of cases or something that arises in the jail to talk to people who have experienced these problems. And Mr. Scott experienced these problems. He knows about them. He could tell me what it was like to be there and could help me develop the facts, which is what I did when we drafted the complaint and framed discovery.
And there's nothing in Rule 23 that requires settlement proceeds to be distributed just on a strict pro rata basis.
That's correct, Your Honor.
And in fact, you have cases that indicate otherwise. I mean, this is an early stage, so I'm not sure this is the stage where you need proof, but I guess it's a question whether it's a matter of law with this costs point of view or a matter of counsel representations. There is some stake. It may not be huge as a personal stake, but there is some monetary stake he has.
That's what the court has previously recognized, and I think there's no developed argument in this case to ask the court to depart from its precedent. Certainly, the en banc court could decide that the 11th Circuit is correct, or the divided panel of the 11th Circuit is correct, and there could never be incentive awards. But this is the wrong case to do that when that argument's made in a footnote.
And you have the first, second, and ninth along with this court.
Have specifically rejected the 11th Circuit's.
I want to shift to this, the issue of delays. When you proposed the class, you talked about anyone who was referred to the oral surgeon but didn't receive treatment in 30 days. In the proposed questions, that time period wasn't there. It just says, unreasonable delay. Why did you shift away from the 30 days?
I was scared of the court's cases saying that it's not our job to legislate a time period. It's very scary when the court says that, and then we try to draft a class definition where there is delay. We know delay is more, and the average more than 60 days. But then if we say, well, it's more than 30 days, then we run into the problem of the court saying, well, it's not your job to it's not our job to legislate time periods, and it's per se an improper class. But we didn't get to the 30 days in the district court's decision. The district court said, you don't have a common question. You don't have a common question because even though everybody in the proposed class has seen an oral surgeon, has seen a general dentist, and the general dentist has made a referral to an oral surgeon for specialized treatment, you have to look at everybody's dental records to see whether they suffered by the alleged policy. What if the jail said, we're not going to provide any dental services if other than extracting teeth? If you have a toothache, if you have dental pain, you can see a dentist, and if it's legitimate pain, we'll pull the tooth. The court would probably say that that doesn't meet standards of decency. It doesn't comply with the 14th Amendment. That's cruel and unusual, even if it was a prison policy. This is the same thing, just one step different. It's saying,
But wouldn't that be, what if that was accurate with respect to some prisoners? That some prisoners, all they needed was extraction. How could we certify a class that says everybody who saw the dentist and was referred to an oral surgeon or needed to see an oral surgeon, their claims are the same?
well, they are the same. There's the general dentist that said, you need to see an oral surgeon. This is an extraction that is beyond the capabilities of a general dentist, and you're going to feel pain for the next 60 days.
Maybe someone would feel pain for the next 60 days. Maybe someone would feel pain for the next 60 minutes. Aren't you defining this way too broadly?
That's a question of evidence, which we don't have here. People who get to see the dentist generally wait 2 weeks to see the dentist, and so that they've already had pain for 2 weeks, and to engage in the magical thinking that the dentist looked in my mouth and my pain went away is inconsistent with reality.
So I want to explore just a little bit, maybe this is from a slightly different point of view. So your proposed class, and I understand, it's sort of filtered by this initial call from the original dentists. But one of the things that bothered Judge Packold was the variety of experiences sort of after that. Some people, I'm not sure what the floor was. Maybe you can tell me, whether the person who had the fastest oral surgeon appointment was 30 days out or 2 weeks out, or I think there's some evidence that maybe it went from 33 days up to 9 months or whatever. But did you ever consider subclasses or anything of that sort?
No, we did not. The evidence about the 33 days came from the affidavit that was submitted after the close of discovery in the response to the class motion based on medical records that were never produced, that we don't look at. And it pains me to say this, but oftentimes the dentist who signed that affidavit gets things wrong. And I'm not going to accept whatever she says based on looking at records. I think she exaggerates or looks at things in a biased manner. So we don't have that in the record. What we have in the record is that the average is more than 60 days. And I think the records were equally available to both parties, and nobody came up with showing that people went to the dentist in a reasonable period promptly after being referred.
And can you say one word about another thing that concerned Judge Packold, which was that the underlying conditions were quite different. Somebody has a wisdom tooth problem, somebody else has a rotten tooth, and somebody else has wires in their mouth, and so on. Is that relevant?
It's not relevant because the general dentist said, I can't handle this. You need to see a specialist. And it's not my job to say how long it takes. That's above my pay grade. And we know that the head of dental services at the jail said we desperately need an oral surgeon at the jail.
So is there any reassurance that it's one oral surgeon or 4 or some other number? Or is that in your view?
We would accept one.
You take one, okay.
Which is what the head of dental services asked for in the budget.
Let me ask you a different question. If a detainee was referred by the general dentist to an oral surgeon off-site and had to wait a long time to go see this oral surgeon, but they're reporting their pain is 1 on a scale of 1 to 10, is that a constitutional violation?
Nobody's ever reported that. Nobody's ever gone to a dentist. My pain is 1, I want to see an oral surgeon. The dentist would say, you don't need to see an oral surgeon. You have insignificant pain. When somebody has been seen and examined by the general dentist and they have a problem that requires an oral surgeon, they have a serious medical need. What if, taking away from dental services, we have somebody with a knee injury in the prison doctor or the jail doctor says you need to see an orthopedic surgeon for your knee. And would we look carefully to see whether it could be solved with medication, or required a knee replacement, or required
But
physical?
would we certify a class? That happens all the time, by the way, in prison. Someone gets hurt playing soccer. They hurt their knee. They come to the doctor. The doctor says you need to see an orthopedic surgeon. They may not see an orthopedic surgeon for 6 months, 9 months. We see this all the time. Then the orthopedic surgeon says you actually need surgery to tear a ligament. Is that a class? Everybody that's referred to an orthopedic surgeon who doesn't get to see one right away is subject to a class?
Actually, the cases that I've read, it takes a while, but that's because of generally in the prison, it's Wexford's policy of requiring the collegial review. Once there's collegial review, they get to see the outside doctor immediately. What if the prison said, we're not going to send anybody to see orthopedic surgeons, you're just going to tough it out. You're going to walk with a crutch
But
or
nobody's saying the prison said that here, are they?
Well, what if they said that? Would there be a class for that? Or would we have to, would the court say, you have to look at everybody?
But that's not what's in front of us. Mr. Flaxman, you're in your rebuttal time. I don't want to take it all up. If you want to reserve the rest,
I'll be glad to answer more questions and need to run a rebuttal.
You can reserve.
thank you.
Thank you.
Okay, Ms. Adair.
May it please the court. This court should dismiss Mr. Scott's appeal for lack of Article 3 standing. However, if this court finds that Mr. Scott has standing, it should affirm the district court's decision denying his motion for class certification for 2 reasons. First, Mr. Scott waived Rule 23b3's requirements of predominance and superiority at both the district court and appellate levels. Second, the district court did not abuse its discretion when it found that Mr. Scott failed to meet all 4 of the requirements under Rule 23. To prevail here today, Mr. Scott has to show that no reasonable person could agree with the district court's decision on all 4 of the elements.
So, Ms. Adair, let me begin with your standing argument based on this 1881 case, which was decided long before there was such a thing as the 1966 version of Rule 23 that we now have. A great deal of your argument was discussing the right to attorney's fees in a common fund situation, which I found a poor analogy to what we have here. First of all, because this isn't a common fund situation, and secondly, because as it happens, this is a 1983 case, so there is a right to attorney's fees under 1988. So one of the big premises of your argument just doesn't apply here. And so if the proposed named plaintiff, Mr. Scott, is out there incurring, the liability for the costs of being the named plaintiff, cooperating with the attorney, then under 1988 principles, I see no reason why there might not be some compensation for that.
Your Honor, with respect to your question about assuming the risks of costs, standing must be for the relief sought. So the relief sought here would just be the incentive award.
That's not actually our law. Now, if you're obviously asking us to convene and bank and overrule a fairly lengthy line of cases, which is your privilege. But I don't find those cases unpersuasive because in the class context, the class representative is in fact getting perhaps more in the way of relief and also incurring more cost. And Rule 23, which allows district courts to evaluate proposed settlements and other kinds of relief, has been used across the country for exactly this sort of thing. So just because the 11th Circuit woke up one day and decided that an 1881 case on a very different factual context ought to be extended here. Actually, there's an 1885 case as well. It just doesn't strike me as very helpful. Since this isn't a common fund case, we have common fund cases under B1, but this isn't a B1 class.
So in terms of the attorney's fees and costs, which you've mentioned, looking at the rules themselves, Rule 23H permits attorney's fees and costs. And our issue
But
is that—
this isn't an attorney's fees point about Mr. Scott. This is Mr. Scott incurring personal risk to move forward on this dental claim.
And I believe Judge Kirsch was correct here. There's no evidence to support that Mr. Scott has services that he provided to the class in the record.
It just needs allegations at this point, as well as a matter of law, that he is, in fact, merely by being the named plaintiff, he is subject to quite a few things, subject to having a deposition taken, you know, all kinds of things that you can't do with the unnamed members of a class, but you can do with the named member.
Well, even assuming he has injury in fact, he needs redressability, that this court has to provide, be able to provide a...
And he easily has redressability. You know, he's, the class as a whole becomes the litigating party as soon as it's certified. So that's what he's trying to do. He's trying to get the class certified. Our law says that, County of Kane, for example. And once the class as a whole is certified, it can get its injury redressed by the appointment of an oral surgeon at the jail. That's what they're asking for.
And I understand that you do not think that Greeno and Pettis are analogous, but the court...
They're not. Well, this is not a common fund case. If it were a common fund case, it should have been certified under B1. But the Supreme Court's decisions in AmChem make that, you know, the Supreme Court has put some limits on common fund cases.
And, you know, I understand that the First, Second, and Ninth Circuit have looked at circuit precedent as the reason why they're not going to find that incentive awards are impermissible. However, they did not consider the case Hall versus Hall, which is something that we mentioned in our brief, which explains how the rules operate. So the Supreme Court, these Greeno and Pettis cases are still controlling and
if it's a common fund, but this is just a different context. You probably know the history of the federal rules. Actually, the original Rule 23 was quite different from the present version, but we're dealing with a 1966 version of 23B3 class action.
And I think...
And that's not a common fund action. It's a common question of law or fact that meets the 4 criteria of 23A and that meets the predominance and superiority requirements of B3.
And that, again, is your position, Your Honor, but, you know, the court in Johnson versus MPAS Solutions, you know, found that incentive awards may be been given due to the product of inattention, right? So maybe courts and litigants, and that makes sense because if you look at how settlements or class actions are typically resolved, it's through settlement, right?
There's no evidence that this is inattention when courts have been doing something consistently for years. That's a pretty grim view of courts, actually.
Well, Hall versus Hall said that, and this is a 2018 Supreme Court case, that, you know, pre-existing practice, so what was happening between the 1880s to when Rule 23 was drafted, stands unless Rule 23 says something explicitly about that we're changing pre-existing practice. So the practice of we're not allowing personal expenses or personal expenses or a bounty to be given to a class representative
for common funds. That was the context.
And it is our position that, you know, this would be a common fund type situation, just like it was in Johnson.
Right, and that's where I'm really contesting. There is no pre-existing common fund that exists. There are no dollars anywhere. There's no bond issue that amounted to a certain amount of money. You're sort of tossing this word common fund around as though it reaches, you know, the money to hire an oral surgeon at a jail. There's no... It's just not a common fund. Go look at the definition of common funds. This isn't it. It's not a bank account. It's not a stock account. It's not, you know, a limited payout from a tax.
And again, it's our position that the common fund doctrine basically came out of Greeno and Pettis, right? They said that this common...
It goes back even further than that. You can have Supreme Tribe of Ben-Hur against Caudle, which is actually a couple of decades before the cases you're relying on. But it was a different situation. Those were the proto-class actions that existed in the middle of the 19th century.
Moving to the merits, unless you have other
please,
questions.
I would be happy for you to go to the merits.
Can I ask you one question before I
Sure.
go to merits? Would you concede that if the incentive award is permissible here, that Mr. Scott has standing?
Yes, Your Honor, but it's our position here that it is impermissible under these 2 Supreme Court cases, Greeno and Pettis.
Let me focus you on the merits now that we are there. Couldn't the district court certify the class if the class were defined as those folks who were referred by the general dentist and had to wait for the oral surgeon for more than 30 days, which is, you know, the original class definition, 30 days or more for treatment by an oral surgeon?
She could have, but looking at the common questions that Mr. Scott presented, both of them rely on this unreasonable delay. And he purposely didn't put in a time period, as he said in other oral arguments he's had before, because a time frame is usually the kiss of death in terms of common questions. He didn't do that in this case, but in order to determine whether or not there was an unreasonable delay, you have to look at things like pain level, what the issue was, and how long there was a delay. So just because a delay may be unreasonable for one detainee in this class, it might not have been unreasonable for another detainee.
But let me comment on that one. It is not uncommon that a class will be defined, and then finally at the remedy stage, where you might need somebody like a special master to distribute a damages award, some members of the class will not qualify. And so if there was somebody who really did, have the equivalent of a hangnail and for some reason was referred by the general dentist, then they just wouldn't get an award. And so, I think it would be even less desirable to have a class that said people who had to wait at least 30 days to be referred and who had a pain level of 8 on a scale of 1 to 10. Now, that's a notoriously subjective scale. The doctors do rely on it, but I don't think that would give you any more certainty in your class action. Even though, looking at the record, there are people who are reporting agonizing pain in their grievances. You could say perhaps anyone who filed a grievance that reported severe pain after the general dentist referred. There are plenty of ways you could fine-tune this class definition without just saying, oh, nothing's common, we're going to throw it out.
And that's true, Your Honor, but that's not what we have here. Someone asked if there were subclasses here. Opposing counsel didn't ask for subclasses. He asked for this general class. And turning back
Is there any reason on Judge Packold's commonality and typicality rationale that he would have done any better with subclasses?
No, Your Honor.
No. So it's a futile gesture. We don't ask people to do that.
But turning to the standard here, it's abuse of discretion. And, it was a very well-reasoned, detailed, on-the-record opinion by Judge Packold on why, Mr. Scott didn't meet all 4 of the requirements.
She thought this was the same as McField's, and I think she's not 100% correct on that. And I'm sure she approached this in good faith. I assume that of everybody. But long doesn't necessarily mean well-reasoned.
And it is like McField's in the sense that McField's involved face-to-face evaluations that detainees said they wanted from a nurse,
right?
And
but
they didn't get them.
But there was certainly no need for all of that. But these are people who've already been through the medical screening and who have not just their own word for it, but a professional who says they need more attention and more expert attention.
And let me piggyback on that. You don't dispute that there is a defined set of skills that the general dentist has. It's a closed universe in the context of this jail. And then there are a defined set of skills that an oral surgeon has. And that's the reason for the referral, right? You're not disputing those basic facts, are you?
That is correct.
So if we have a class of people who've seen the general dentist and then who are referred, that means the general dentist couldn't help them anymore. And they necessarily need the skills of what the oral surgeon can do.
That is correct, Your Honor. But again, I think Judge Packold correctly saw that some of these detainees were going to get a wire of their braces off. Some of the detainees had a rotten tooth, and none of these detainees had emergency situations. I think that's important because if they did have an emergency situation, then there was a separate process that they would be sent to the oral surgeon on a more expedited basis.
So how long are people supposed to be in pain? It's not an emergency. It's not going to kill you, but you have, a rotten wisdom tooth, and you can't sleep at night. Are you supposed to go like a week or a month? How long do you go?
I don't have an answer in terms of a time frame, but all these detainees had access to a dentist on site. So if they needed to go see the dentist again because they were in
But
pain.
they've already been told by that dentist that I can't help you. Your problem is beyond my skill.
Right, but they still had,
So it's good that they just hear that repetitively?
well, the Constitution says that you have right to adequate dental services. It does not say that you have a right to an oral surgeon on site at the jail. And I think that's important because just because, they had to wait, all of us have to wait sometimes to see providers, but just because they had to wait does not mean that there was a constitutional violation. And to bring it back to the class, Rule 23 requirements, to make this broad of a group, a class, was correct. That she said this was not enough to satisfy all 4 of Rule 23's requirements. She did not err in terms of typicality, commonality, superiority, or predominance, and I think predominance is key here. So even if you say that these detainees all were subject to waiting to go see an oral surgeon, like this court has found in McField's and Phillips, this common policy, is only one small part of whether or not there was a constitutional violation under the 14th Amendment. And going back to predominance again, the common issues have to outweigh any individual ones. And Judge Packel correctly found that the individual issues here from all the detainees, so again, the varying pain levels, what they were going for, and how long they waited, was just too different. So, does this court have any other questions?
Nope.
We ask that you affirm the district court's decision, or alternatively dismiss Mr. Scott's appeal for lack of Article 3 standing. Thank you.
Thank you, Mr. Dare. Mr. Flaxman.
If there are any further questions?
Yes, I have a question. How do you respond to the appellee's argument regarding waiver? Because do you agree, is it your position that you addressed all the 4 of the Rule 23B requirements in your brief?
We wrote all the 23A, all the 4 requirements, and we discussed 23B3 with the appropriate specificity that's required for this kind of case. And no, we didn't waive anything. That's
Okay.
While I'm here, Phillips reference to Phillips is interesting because in footnote 39 of Phillips, the court cites a Ninth Circuit opinion which certified a class based on understaffing. And on remand in Phillips, that's what the district court did. She certified a class based on understaffing, and the ending date of that class was when there were enough dentists. And the questions about what the class definition should be bring to mind this court's decision in Fonder versus Kankakee, where the court held that the district judge has the authority, the power, and the duty to redefine the class if she or he doesn't like what the plaintiff proposed. Thank you.
Thank you, Mr. Flaxman. The case will be taken under advisement. Our next case for argument is Montoya versus Jeffries, appeal number 22-2791. Hold on for 1 second, Ms. Nichols. Okay, you can begin whenever you're ready.
Morning, may it please the court. The United States Supreme Court has recognized the rights of parents to the custody and upbringing of their children as one of the longest standing fundamental rights. That right is entitled to respect and, absent a powerful countervailing interest, protection. Under Illinois law, a condition of mandatory supervised release for any individual who's been convicted of a sexual offense is that they refrain from all contact with minors without the prior approval of an agent of the Department of Corrections. When that amount of discretion is given to the Department of Corrections, it is incumbent upon them to implement procedures and policies that ensure that right is not deprived for arbitrary reasons.
So, Ms. Nicholas, can I just get one maybe big point out of the way? You did not discuss in your brief the Fels decision, Fels against Fiedler, about the standard, but I read that to be actually quite clear that in this circuit, the Turner against Safley standard applies to our evaluation of the measures that the state has chosen to take here. Would you agree with that?
You're correct that in Phelps, this court applied the Turner v. Safley standard to the evaluation of a parole condition that affected the constitutional rights of the individual on parole. I think what is missing from the state's analysis here is that Turner is receptive to the context in which it's being applied, meaning that both the rights of the individual and the interests of the government are different in different settings. So, for example, a restriction that may be perfectly appropriate and permissible in the prison context may not be appropriate and permissible when someone is on supervised release. Because
but why does that help you? I mean, to take exactly that situation, the state emphasizes with respect to telephone calls, which seem, less risky than, say, in-person visits, but they say in the prison we're already all set up, for telephone calls. We have monitoring capabilities. If somebody starts to become psychologically abusive, we can cut things right off there before the child is injured. And it's just not like that out on the outside once a person is on mandatory supervised release. So doesn't that sound pretty rational under the Turner standard?
So I think that under Morrissey, a parolee's constitutional rights share many of the same core values as the rights of a free person, and that includes the right to the enduring attachments of normal life, such as to one's family. So there has to be a higher standard for respecting that right once somebody is out in the community. Otherwise, the purposes of mandatory supervised release will simply be undermined. So I think this court in Brown versus Phillips recognized that Turner is receptive to the context in which it's being applied.
Do you have to invoke the idea of a higher standard to even make that argument? Isn't it just that Turner does make room, it recognizes context, and one context that's important here is that on parole, there are goals of parole that aren't the same as the goals of a penitentiary or a prison environment. And two of the goals are rehabilitation and reintegration in the community. So then when we get to the issue of phone calls, for example, when doing this Turner analysis, you need to pay attention to that context and those differing goals and how that affects those goals that are different from a prison.
That's exactly right.
Why is it necessary to invoke this idea of a different or higher standard?
You may be absolutely right that it's not necessary.
Why is that a question for the courts? Why is that not a question for policymakers? I mean, if the test is a rational basis and we disagree with the rational basis, why is that our job to tell the other branches of government, you stated a rational basis, we all agree it's rational, but we just disagree with your policy decisions, and therefore, we find a constitutional violation.
So Turner just doesn't look solely at whether there's some plausible rationale for the restriction.
Well, that's what it says. I mean, so you're saying we shouldn't take it at its word, okay? We shouldn't read the language. We should look deeper and evaluate and exercise our judgment on the value of the policy.
So Turner contains 4 factors for the court to consider, and that last one is whether there's readily available alternatives to the restriction that suggest it's an exaggerated response.
Okay, what you're asking there is for us to say we as judges think it would be better for the parole board to be making these decisions, and therefore it's a constitutional violation for them not to. That's pretty dramatic, I think.
I think I want to separate the substantive claims from the procedural claims, because I think it's quite clear that the procedural claims are not subject to the Turner analysis.
Correct.
They fall under Matthews.
They're Matthews against
Exactly.
Right.
And so when you get to the procedural claims, you have to look at the Matthews factors rather than whether there's some rationale articulated for the restriction. And I know I have very limited time today, so I'm hoping that I can focus on those procedural claims, particularly who is rendering the decision here. And I think there's 3 reasons why therapists, who are the principal decision makers under the department's current policy, simply are not the appropriate people to be making the decision. about whether a parent can maintain his or her ties with their child while on supervised release. First, they may have good intentions and some expertise in treating these folks, but they have interests and motivations that raise concerns about bias. And it should come as no surprise that they are treating parent-child contact as a privilege to be earned rather than a right to be respected in the absence of evidence that there is a specific and articulable risk to this parent's child. As Dr. Blaine testified at some length, he wants people to have motivation to make progress, motivation to respect all of the rules, things as minor as their curfew. And so he's withholding his approval for parent-child contact to give them motivation to reach those goals.
Did Judge Feinerman say as a finding of fact that that's just an aberrant misunderstanding of the policy? I mean, I get where you're going with this, but didn't Judge Feinerman deal with that as a factual matter and disregard it, essentially?
And I think that was really an error because this is a feature, not a bug. This is exactly what happens when you give.
So what about the appellate process? Because whatever you deal with, whoever is the decider here is not going to ignore the therapist, right? So the therapist is going to be the primary witness. You can have a district judge be the decider, and the therapist is going to testify and say, this is what I think. And the judge is going to say, well, I've got the testimony of a therapist. I'm neutral. I make a decision in large part based upon the therapist's testimony. Don't you have that here with the appeal process?
A couple of responses to that. One is that if we have a neutral decision maker, that won't be their sole source of information, right? No one is disrespecting the expertise and skill of these therapists. They can and should weigh in. But the neutral decision maker should also hear from the parent, the child, the custodial parent, the person who has custody of the child, other therapists that might also have seen this person. Right now, none of that is taken into account because it's just the treater is making the decision. And I think there's an analogy here, which is that no one is saying that the therapist doesn't have skill and expertise. No one is saying their input isn't valuable. But the analogy is to the context of policing and arrests and searches.
So can I just interrupt? I just want to make sure I know which half of the case we're on right now. Are we talking about the substantive reasonableness of what's going on, or are we talking about whether the Matthews against Eldridge process should be before different bodies or with different decision makers, or kind of the more classically procedural?
I'm focusing on the procedural
All
issue
right,
right
so,
now.
So we're talking about procedure. Judge Feinerman was saying, you know, this team of people that the state says are the ones responsible is a real thing. It's not just a window dressing to cover up the fact that the therapist is a dominant voice, or the dominant voice, perhaps. And what worries me about your position is just going through the factors. One of the factors is the value that additional procedures could give, but the other is, of course, just the risk of an erroneous decision. And here I have trouble separating the state's strong interest in protecting children alongside of the strong interest of the parent. This isn't a one-sided, only one party has a strong interest. There are important things on both sides of the equation.
And that's precisely why someone detached from the supervision and treatment of the individual should be the person rendering the decision. So, for example, we all want crimes ferreted out and solved. It's no disrespect to the skill of police officers that we require a warrant for searches of homes, and we have a judge weigh in on that, or we require a neutral magistrate to weigh in on probable cause to detain. So I think that to properly balance those interests, which are both strong, you have to have somebody detached, neutral, unbiased, making that decision in the first instance. So one other point I wanted to come back to, Judge Kirsch, on your question about the appeals process. I think it is cool comfort for someone who is going to be subjected to this grievous deprivation of their constitutionally protected rights that they can later appeal that decision to someone else. And even if this court thinks that someone like the manager who is overseeing the SOMB is theoretically neutral enough, you're entitled to a neutral decision maker in the first instance, particularly whereas here the right at stake is so important and so vital to the people who are being subject to this deprivation. I think in the United States Supreme Court Ward versus City of Monroeville, the court rejected the idea that you could cure the lack of a neutral decision maker in the first instance by later being able to appeal to somebody who might be neutral.
Let me understand your position on the parole review board. As I understand your argument, you think the parole review board, or prisoner review board, should be the proper entity. And your position is we're not throwing the therapist out. The therapist is a major witness, but also, you know, the board could hear from other folks. Are you envisioning this happening on a post-release basis or a pre-release basis?
People need to know what their terms of parole are going to be before they're released, and that is for very practical reasons, such as where can you live when you are released? We have clients who, some of whom are discussed in our brief, who stayed in prison because they couldn't go home to their own families.
Let me ask you this. So I hear your answer to be pre. What would be the error in taking that same scenario you envision and doing that on a post-release basis, but with the deadlines that you all say is so important?
Yeah, it's certainly better than what we have. It is certainly a more fair process to have a deadline in place, a neutral decision maker, and a prompt post-deprivation process. I think that it does raise some real problems for people who cannot plan their lives before they are released from prison onto supervised release.
But
For
what
example,
do you do with all of the findings that the district court made about the unsatisfactory nature of the information that's available at the pre-release stage, and that only after release, maybe for some, it doesn't have to be forever, 30 days, I don't know, for some period of time though, post-release, see how this person is adapting to obviously a very different environment.
so a couple of thoughts.
I mean, he certainly says that. He goes on for pages about that point.
One, under Carey v. FIFAS, the right to procedural due process is absolute. So it does not depend on someone's success on the claim that they're entitled to release. But right now what is happening is the pre-release evaluation that is done is not even being taken into account. Any other therapy the person has gone through is not being taken into account. The input of the custodial parent or the child is not being taken into account. All that is happening is a presumptive ban is being imposed, and that is problematic. So I see I'm well into my rebuttal time, so if I can reserve the remainder. Thank you.
Okay, thank you, Ms. Nicholas. Ms. Schenevert.
Good morning, and may it please the court. I am Assistant Attorney General Caitlin Chenevert, and I represent the defendant appellee. The district court properly concluded that the department's policy governing requests made by convicted sex offenders on parole to have contact with their minor children was largely constitutional, and the district court's factual findings supporting that conclusion were not clearly erroneous.
So let me ask you about one part of this that bothers me. I take it that we're all comfortable on the substantive level that we're talking about Turner against Safley. I take it that we're all comfortable on the procedural level that we're talking about Matthews against Eldridge. But when the district court got down to applying these standards to the particular restrictions, the only thing he singles out really is written communications. And I thought that given the importance of the parental relationship, he slid too quickly over stories of the difficulty, let's say, of monitoring phone calls. I don't see why, for example, you couldn't say if you're going to have a phone call, you have to come to the probation office. If you're going to have a phone call, you have to, let me place the call, and it's going to be a three-way call. So I mean, these are not complicated things to arrange. It's not that the prison has all this capability that's not out there. And I felt that it really underestimated the critical nature of that parent-child relationship, even giving you the fact, which I do, that it's a very important interest on the side of the child's safety. It's a very important interest on the side of the parent. It's something that needs to be balanced. We're not here, as Judge Kirsch says, to micromanage that balance, but to cut people off for such lengths of time is a very drastic step when there's nothing in the system to push it forward.
So, Your Honor, to respond to your point, as far as having individuals come into a parole office, I believe you were discussing.
Yeah, make the phone call there.
For phone calls.
Yeah.
So a couple of points.
Have their cell phones disabled, monitor the cell phones, whatever you need to do.
Well, so I would note that likely would create some kind of an administrative burden for the department, just as far as ensuring that the facilities were available to the extent that they didn't need to be used by other.
So you make appointments. I mean, there's a probation office across the street from this building for the federal probation officers, and it's open rooms. They make appointments, when people can come. It doesn't mean you necessarily have the right to a phone call every afternoon, but maybe every other week is a lot better than 0 for a year.
Well, additionally, though, Your Honor, I don't believe that the plaintiffs actually ever proposed that as an alternative way for, at least for phone contact.
Well, there was just this blanket statement by the court that trying to replicate what was going on in the prisons would just be too burdensome. More than a de minimis burden, actually, is what he says. And I'm not sure that's even the right standard.
Well, again, certainly the plaintiffs here have not specifically identified even that. As I recall, the plaintiffs did not, in the district court, argue that would be a reasonable, feasible alternative that would not place significant administrative or fiscal burdens on the department. So that's.
I'm not sure they ever reached the point where they had the burden to do that, though, because what the state was just saying was, our system is permissible, end of discussion. We don't need to talk to you about any features that would better respect the parental rights of the people who are on mandatory supervised release.
Well, certainly, though, again, the district court made significant factual findings, as Your Honor mentioned, about the importance of being sure that there's a way before even allowing contact to ensure that the department has time to gather some evidence about post-release evidence. The district court credited the testimony that pre-release evaluations cannot be used because there isn't that post-release evidence.
But the court also, in the face of that, does single out the written communication. So what I'm worried about is that the court seems to have assigned a value of close to 0 to the parental rights and a value of close to infinity to the rights of the state. And I'm not convinced, under the correct Supreme Court decisions that discuss parental rights, a somewhat different line from either Turner or Matthew, whether that's correct, whether the parental interest is approximating 0.
Well, Your Honor, again, the district court did acknowledge that there are significant parental rights at stake here. But again, even with communications via telephone, there would still need to be, I believe the district court correctly determined that there would still need to be some kind of post-release evidence that the department could take into consideration to determine whether or not those types of communications may even be appropriate.
Why does telephone become dangerous the day you walk out of prison if you've been having telephone contact with your child through the period of your incarceration?
There was evidence, there was testimony during the trial that when there are communications in the prison setting, those are closely monitored. It's a controlled setting, so there's ability.
So you have a database. You know that so-and-so has never abused his phone privileges in the prison because it was closely monitored and was under that general regime.
Correct, but there was also testimony that once an individual is released from prison to serve their parole term, there are a lot of variables that can come into
That's why I said maybe you can bring them in. I don't know why it's so black and white.
Well, there was also testimony, and I did not see any nod to this by the district court, that therapists themselves, whose testimony the district court credited on all manner of other subjects, therapists also said they didn't see phone as particularly high risk for these clients.
Certainly not as far as physical harm, but there was testimony that there could still be psychological harm that may happen during phone conversations. And in fact, Dr. Blaine himself testified that he also believed that phone conversations were riskier outside of the prison context. And so there is still a potential risk of harm there.
Now, is your position the district court has this obligation under Turner to evaluate any reasonable alternatives. Would you agree? I mean, I hear you taking the position you felt that plaintiffs did not raise the idea of these other ways to accomplish the phone calls. The district court had an independent obligation to do this Turner analysis.
That's correct, but I believe based on the evidence presented and the testimony and the evidence presented to analyze whether or not, based on that, there were any reasonable alternatives.
But the district court's whole plan for how written communication should take place, he creates a whole regime for that. The district court created that all on its own. Am I correct in my reading of the record?
Correct. Well, the district court found that there was the concerns for phone communication were not necessarily present.
In other words, I
But
guess
it's
what I'm
actually
asking.
very specific. I think that's what.
Yeah, the plaintiffs did not
Johnson's talking about.
put forth this menu and a whole proposed policy plan for the district court on these written communications. The district court on its own created this very detailed new regime for written communications.
I believe that's correct. Your Honor.
Okay.
Yeah, I believe that is correct.
And the difference, though, I thought, was that the district court found that there is this very de minimis burden. I mean, I could review a letter in 1 minute, where if it was read to me, it might take 8 minutes. I mean, just, the burden of saying I'm going to send a birthday card to my child, here's the birthday card, would take a parole officer 15 seconds to look at, where monitoring a phone call and setting up a phone call and then listening to the phone call.
Correct.
There's a much bigger burden there. I think is what the district court found.
Correct, that's correct, as well as the fact that the issue of the immediacy is not there, right? There's a bit of a lag time between the written communication being sent.
Well, that's true, but Diane, our Judge Wood makes a good point that you can schedule an appointment.
You can schedule appointments, and you can even say, if you're going to have this here, you have 5 minutes, to keep the burden of review to something manageable. Just touch in, I love you, honey, have a good week.
You could also have the therapist monitor phone calls.
Let me ask this. One comfort to the district court and to the state I see is that there's this appeals process. Is the appeals process reasonably available to parolees, where there's testimony that parolees did not know that they could challenge a decision that it was taking too long in some particular way? They did not know how to contact Ms. Brown-Foyley's, that it's not written down for them how to do X, Y, and Z. What's your position on that?
So, Your Honor, my response to that is that there is testimony that this is a written policy that is provided to parolees once they are released onto parole during their initial meeting with their parole agent. They are provided, this written policy. To the extent there was testimony that certain parolees may not have received a written response or received the written policy, that may be the basis for an as-applied claim that an individual brought to state that they couldn't actually, the appellate process was not available to them. But plaintiffs here have brought plaintiffs here have brought a facial challenge to the policy, and so there was certainly testimony, and actually the department's policy at the time was introduced as an exhibit at trial, stating that this is a written policy that is provided to parolees. So again, to the extent that there may be one-off situations where individuals aren't receiving the information or haven't received a written response, that may be a separate question for an as-applied challenge, but this is a facial challenge.
But I'm talking really on a granular level, because the detail came out so many times that parolees could just contact Ms. Brown-Foyley's if they were having a problem. So your position is they were told in writing they could contact her, and this is how. This is her phone number, this is her email address.
Excuse me, Your Honor, I don't believe that is correct. In the written policy, I do not believe it provides her contact information or directs them to her, but it does state that once you receive a written response regarding your request for contact from the containment team, that an appeals process is available and that a form will be provided to the parolee in order for them to fill out to complete the parole.
So it's a broad statement is what we have in the record. An appeals process is available to you, full stop.
There was testimony about that in the record, but the department's written policy was also entered into the record as evidence.
What I'm asking is that the extent of what they are provided?
As far as, if I understand Your Honor's question correctly, when they're having their initial meeting with their parole agent, if that's the extent of the information that's provided to them is just the written policy, Is that?
The content of it, in terms of the appeal, what level of detail is provided to them about how to appeal?
Your Honor, I believe that the written policy itself states that once the parolee receives a response from the containment team, if the parolee wants to appeal that decision, that they will be provided with another appeal form in which they can fill out the information and then submit the appeal form to their parole agent. Speaking as to the plaintiff's procedural due process claim, although this court in the Felsey case determined that the process there did not pass constitutional muster, there are significant factual differences between that case and this here that meet, and the district court properly concluded that the procedure here satisfies constitutional requirements. One of the several factors that this court considered in Felsey that it determined meant that it did not pass constitutional muster was the fact that as a part of the appeals process, one of the factors it noted that there was no provision for review by persons not currently involved in the individual's diagnosis or treatment. That's certainly not the case here. Again, the appeals process allows an individual who is not involved in any treatment or supervision to review the containment team's decision. I would also just quickly like to respond to plaintiff's counsel's point regarding the necessity for someone outside of the Department of Corrections to review this decision, to review the containment team's decision. And Felsey, as well as Washington versus Harper, make clear that a neutral decision maker does not necessarily need to be outside of the institution.
And you think that will survive the current Supreme Court's decisions about SEC administrative law judges?
I suppose there's a chance that perhaps not. However, this court again in Felsey specifically noted that a decision maker need not be external to an institution in order to be independent. So there's certainly,
so at least for the time being, you're making this argument. Okay.
Another point I just want to address, the plaintiff's counsel mentioned a reason why a therapist should not be the individual making this determination. Again, as the district court found and as this court noted, in fact, the containment team collectively is making the decision, therapist as well as input from the parole agent and the parole commander. So it is
even though they never disagree with the therapist. I mean, the evidence is pretty clear that. Let's just say there's tremendous deference to the therapist.
Well, but certainly the department's deputy chief of parole testified that there is no policy that anyone automatically defers to a therapist, and each case is decided on a case-by-case basis. For all these reasons, we ask that you affirm the portions of the district court decision finding the department's policy to be constitutional. Thank you.
Thank you, Ms. Nicholas.
Thank you. I'd like to just speak briefly to the appeals process and its adequacy. 2 points. First is the forms that the department created have to be considered as part of this policy. And the forms allow the therapist or the parole agent to simply check a box that says insufficient therapy sessions to make assessment and give that to the parolee as the sole basis for denying them contact with their child. As you saw in the record with Mr. Velna, he received that form 10 times in a row, and he tried to appeal twice, but he had no idea why his therapist was refusing to make a recommendation. So really the ability to appeal has been frustrated by the department's
and just to be clear, he was having regular visits with this therapist?
Every week.
Yeah.
And the only way the appeal process is relevant, though, is if we find that the district court was wrong, that the therapist is not a sufficiently neutral and impartial decision maker, right?
I mean, certainly the involvement of a neutral person at every level is important, but the therapist and the parole agent just simply aren't neutral in any meaningful way. The other thing
Simply because the therapist is treating the individual,
exactly,
that makes the therapist not neutral. I mean, I think therapists would disagree with you, by the way. You start from that premise to get to the appeal, and I think therapists would vehemently disagree with you. And they would say, no, we are neutral.
Well, I'm curious your reaction to that, given the testimony of the therapist about the distinct roles between therapy and evaluation.
That's exactly right. Dr. Blaine himself testified that it was a potential conflict of interest to be both the treating therapist and the evaluator of risk. And the SOMB standards to which the department cited are consistent with that, which is that an appropriate evaluator is somebody who is coming in neutral, doing the risk assessments, doing the actuarial tests, and making a decision from there. And then just one final point about what happened in the Fels case, which is that there were 3 levels of grievances. You could grieve to people who weren't the initial decision makers. You could grieve to people who weren't your treater. But this court still found that that process was insufficiently neutral to make a decision affecting somebody's constitutional rights, as we have here. So we're asking the court to reverse the district court's decision. Thank you.
Thank you, Ms. Nicholas. And the case will be taken under advisement. Our next case for argument is United States versus Ross, appeal number 23-1640. Mr. Skaggs.
Thank you, Your Honor. May it please the court, I'm Ethan Skaggs. I'm an assistant federal public defender for the Southern District of Illinois, and I represent Tony Ross. Mr. Ross is a convicted felon. He's a convicted felon who had a job. He was working in a Jack in the Box when he was approached by agents that wanted to talk to him about an investigation. At that point, Mr. Ross takes a pistol and tries to hide it.
You agree that that pistol was used in crimes, right?
Several
You're
crimes,
not. Yeah. Okay. I just want to make sure you're not challenging the ballistic evidence. You didn't challenge that below, and you're not challenging that fact on appeal, right?
That's absolutely right.
Okay.
That is not our appeal, Judge. Mr. Ross pleads guilty and ends up with a 90-month sentence after having a high-end guideline of 46 months. A 95% increase over his guidelines. You know, the district court talked about his criminal history. You know, Mr. Ross's had juvenile cases that didn't count. He had all his adult cases counted for points in one way or another. His felonies counted for points. One of them was a crime of violence. That increased his offense level.
So, Mr. Skaggs, just to kind of cut to the chase, I understand you to be making, in a sense, 2 arguments. One of them may be may rely on the consistency of his sentence with other, as compared to others. But the other, if I'm correct, you're concerned that the judge's reference to this gun, that the ballistics connected to homicides and other criminal activity, somehow indicated that the judge was taking a factor into account in the sentencing that was not tied at all to Mr. Ross, and that was error. And I want to focus on the second of those right now. I mean, the judge doesn't harp on this or anything. He does mention this evidence about the gun. Do we have a record that would undermine our confidence in the judge's sentencing because of that reference?
The first time he references, I would agree, is a fairly short reference, where he says, maybe it's bad luck, if. Jumping ahead, Judge, it's the second time he references, I would say he's
19,
made
20
the
or
leap.
so, when he says you just happened to be caught with a gun, etc. Oh,
Well,
that's the bad luck one. Yeah,
The final
one.
reference.
Yeah. Okay.
He's right before he pronounces his sentence, his comments. I don't think the sentencing guidelines adequately takes into consideration and you have a gun and it's linked ballistically to a homicide and another shooting at the Roosevelt Zone in less than a month or about a month or a little over a month, February 20th, 2022, March 23rd, 2022.
But he doesn't link the defendant to those crimes, just the gun.
I would say the context there, Judge, he is linking him to those crimes. Especially
But
when it's-
you're reading a lot into that. I mean, wouldn't a fair reading of that to say you possess a crime gun, which makes it more dangerous. In other words, you didn't go to a trade show or something and buy a gun. You're possessing it, and I think he even goes so far to say, whoever gave you this gun did you no favor, indicating that he was not the killer.
Early on, that's what he's saying. My point is what he finally says, because what I just read is, that's the last thing he says before
Right.
he pronounces his sentence. So perhaps initially he wasn't making that leap or making that connection. But in the
I
end...
mean, we can all agree that there is, in fact, no connection between Mr. Ross and the crimes that the gun was associated with. No one ever tries to connect those dots.
All we know is there's a ballistic report that the government mentioned in their sentencing memo.
Can we back up? Whatever the district court meant here, it is clear he says, I don't think the sentencing guidelines adequately take that into account, adequately take it into consideration. And then he pronounces the sentence, which has the variance. So is your reading of this that part of the reason for the variance is because he doesn't think the guidelines take into consideration whatever it is he means to say about this ballistic evidence that was not supported at the sentencing hearing?
Our position, the reading of his last comments before he pronounces his sentences, he has at that point taken that gun and put it in Mr. Ross's hand and is assuming he's a shooter, and he is attributing those crimes to him.
What I'm asking you is, even if he's not saying that, he could be saying, you know, you're just as well may well have been the shooter. You have this gun, or he could be saying, as Judge Kirsch said, you know, you're walking around here with guns that have been used by other people in other crimes, and that's bad too. But whether it's one or the other, he is in fact saying, I don't think the guidelines account for this, so I'm going to account for it with my sentence. Would you agree?
I don't know that he's accounting for the fact that this gun is out there and it's committed other crimes, because the question becomes at that point is, how does that affect Tony Ross and what he's done in making a decision what to do with it? If it is a crime gun, we know that this gun committed crimes. Mm-hmm. And we know it committed several crimes while Tony Ross is still in prison. So there are a lot of things on this gun, but you can't put them in Tony Ross's hand. And that's our issue, is this, at the end, it seems like he's putting it in his hand.
Do you think it contributed to the variance?
Yes, that's our position, is that very much contributed to the variance. And I say that just because of the timing when he's bringing it up. The last thing he mentions before he decides to give him the 90-month sentence. So.
If we agree with you, though, Mr. Skaggs, don't we need to say, in our opinion, here's what the district court said, but that's not what the district court meant? Because I think you have to concede that the district judge did not assign the crimes to Mr. Skaggs, and to Mr. Ross. But Mr. Skaggs, you made a good argument. I think you represented him at the sentencing hearing, right?
I did.
And you made a good argument. The judge, look, this is not persuasive evidence because several of the crimes were committed with the gun while Mr. Ross was in prison. So he could not have committed those crimes. Therefore, you should not conclude that he committed these crimes either. And nowhere does the judge say, well, I'm going to assign the crimes to him or infer that he committed the crimes. He does the opposite.
He never specifically says that, Judge.
Well, he never specifically says it because there's no evidence. I mean, I guess it would be weird for the district judge to say, I find that you did not commit crimes based on this record, right? He just doesn't say that I found that you committed them or I'm sentencing you because you committed them. We would have to say, here's what he said, but he didn't mean what he said.
But what about the ambiguity? I mean, you know, he makes these statements about the guns, but I want to back up and ask you to address one of the things Judge Kirsch said a few minutes ago, which is, you know, that if you are in possession of a gun, that the gun somehow on its own, you know, committed other crimes as though there were no people involved somehow. is that something that is a proper thing to use to enhance a sentence? That some other person at some other time that we don't know anything about committed crimes with this gun? I mean, the judge doesn't even say you were engaged in the illegal purchase or transfer of a gun. I mean, there's a lot that's not said.
I don't see how we can attribute something that's happened with a firearm to the person that later possesses it. There's nothing any guy, I guess,
We
in
wouldn't
ways
want to
you could
go
say
there. I
with
mean,
the
a
guy.
person with a completely legitimate gun could have it stolen from their house one night, and then a criminal could go out and do something and then return it to the front porch, and you certainly wouldn't charge the homeowner.
And there's certainly not a guideline provision that says you need to be held accountable for what's happened with this gun. Other than, I guess, arguably you could say the stolen firearm enhancement.
Mm-hmm.
You don't have to know that the firearm's stolen, and you get the enhancement.
Right.
So I'd say the rest of my time for rebuttal.
Certainly, Mr. Skaggs. Ms. Burns.
May it please the court. Allie Burns on behalf of the United States. Mr. Ross's 90-month sentence was not a result of procedural error, and that sentence was substantially reasonable.
But why is the history of this gun even remotely relevant to the sentence that Mr. Ross should get? I'm troubled by the thought that there's this gun and somebody goes and does ballistics tests on it, and the temptation in your mind to link it to him somehow or another is a strong one, and yet it's irrelevant.
Sure, Your Honor. I think based on the district court's statement, the tone of the statement was not holding Mr. Ross accountable for this homicide and this shooting that happened within a month or so of him being found with that gun. What the court was linking was outside of just talking about the ballistics, but the continuous theme about Mr. Ross is his wanting to be involved in violence and his connection.
But why does the gun have anything to do with that? I mean, he says it could have been a perfectly legitimate gun. You went to a gun show, and or you went to Joe's Firearms and bought a gun, and I don't know why it tells you anything about the sentence for this 922G offense.
I think, I would say first, I don't believe that this was the basis for the court to sentence him to 90 months. I think the record was clear. There were infinite other reasons that above guideline sentence occurred. However, what I would say
So maybe are you arguing then that the reference to the gun should be viewed as harmless error?
Absolutely. I think the reference to the gun, while the court absolutely referenced it, I mean, I can't dispute that, the record speaks for itself, it was more of a passing thought. And I think the last statement that the defense has raised, again, if you look at the record, he says, oh, and so it's almost like a passing thought, something else he just wanted to reference, but it wasn't the reason for the
Well, he
sentence.
says,
Go ahead.
he says, I don't think the sentencing guidelines adequately takes into account. But before we go on and you continue, have you waived harmless error as an argument here? I don't.
Can I ask one question to follow up on that? Are you conceding it's error?
No, Your Honor.
Okay,
No.
now have you waived harmless error? I don't recall you raising that in your briefs.
No, Your Honor. I guess what I should say is we're saying it's not an abuse of discretion, and that the sentence was substantively reasonable. That was not a procedural error by any means in him referencing that. And I don't want to disregard.
No,
your
no.
question.
I think when Judge Wood asked you a question, I think it could be interpreted as you conceding that there was error in relying on the
No,
ballistics
I
report.
only meant if we were to decide it's error, not your argument, but if we were to think that, would it be harmless? Was kind of the way I was trying to put it.
I think the way I understand what the district judge was doing is suggesting that the defendant could be viewed as a little more dangerous. This is a little weird, is what the district judge is saying. He works at a Chick-fil-A. I forgot the name of the restaurant.
Jack in the Box.
Jack in the Box. Jack in the Box. And he goes in. We don't have Jack in the
It's
Box
a
around here.
Texas thing.
So he works at Jack in the Box, and the police go to interview him, and lo and behold, he's got a gun in his waistband working at Jack in the Box. It's not terrific facts, right? And then to find out this is not just any old gun, this is a crime gun. And by the way, There are certain guns that require enhancements. Like, for instance, if you have a gun that has an obliterated serial number, that makes the gun more dangerous, and therefore you get a 2-level enhancement. I think the district judge is saying, look, this gun was used in a murder. That's something that I should consider here, and I'm going to consider it. And then we get to whether it was substantively reasonable for the judge to depart, at least in part, based upon the consideration that this gun was used in. It's a crime gun. I mean, that's what it is.
Correct. And I think that is the tone of the court's statements, is more that Mr. Ross is connected to this criminal element. Like, it's not that he committed these crimes. He's not holding him accountable to that, but that this is not a firearm that was found in his house left for him to his grandfather.
I understand why the government raised it. And the government put a line in a sentencing memo and then mentioned it again at the sentencing hearing. What I can't understand, and I want you to address, is why it was proper the way the government introduced this at sentencing.
Your Honor, I think it was proper because first I would say, and defense conceded, that they waived any argument to the accuracy of that ballistics report.
No, they're not making it because he would lose acceptance of responsibility if they did. I think that Mr. Skaggs' argument is we are not challenging the ballistics reports. If we did, that would be a factual argument, and Mr. Ross would certainly lose acceptance of responsibility once the government called an ATF agent who testified undisputedly that the gun was used in a murder.
Sure. And I think the reason, though, that it's relevant is just going back to the prior...
No. I'm not questioning the relevance or anything. I'm wondering why the government did not, submit the FBI ballistics report or the letter saying this, or put somebody on the stand. Because, we have this clear law that the court's got to rely on. The court can only rely on supported statements, as evidence. Separate and apart, we know the rules of evidence don't apply at sentencing, but it has to be reliable. It can't be allegations and attorney statements, even if it's the attorney of the government. Attorney statements don't survive a due process challenge. Certainly, if no one challenges it, attorneys say all sorts of things at sentencing. And the district courts talk about it and rely on it, et cetera, all well and good. But once we're at the stage of it's a due process challenge, our law is that an attorney statement is not supported. That doesn't reach the probable accuracy threshold. I'm trying to understand why you think it does, absent some extrinsic evidence here.
Your Honor, I think it would tie back to the fact that it was undisputed. Like, and it was disclosed in discovery, it was brought up prior to the sentencing hearing, so if there was any dispute to it, then evidence could have been put on and the record would have played out differently. But because there was no objection, in fact, the defense relied on it in their arguments to distance Mr. Ross from other crimes in it, that I don't think there was any obligation to, because it's not just attorney statements. It was disclosed in discovery and undisputed.
It's the same reason you don't submit certified conviction histories for every single conviction of the defendant. You just look at the pre-sentence report, no objections to paragraph 20 through 38. That's it. We move on.
But he's not disputing the accuracy of the ballistics evidence. He's disputing what he sees. And, it's a separate matter from what we will see when we look at it. But what he sees as the inference the government was asking the court to draw from all this, which is linking Tony Ross to this gun.
And Your Honor, I would say that's absolutely not the inference that the government was making. It was very clear. There was one sentence in my sentencing memorandum that stated the firearm was ballistically linked.
I understand that. And then he's also disputing the court's reliance on this as a basis. And I heard you to be saying, at the end, it is a basis. It's just that the court had plenty of other bases too, but as a basis for a variance when it was not supported in the record.
And my reading, and I was also at the sentencing hearing, and my recollection of the way the court made that last statement, and you see it in the record.
It doesn't matter the way the court made it. We just read the words, okay?
Sure.
And we have to say we reject what the district court said because that's not what it meant.
Correct.
Right? We have to. If we're going to say we're tying the gun to Tony Ross, we have to say we reject what the government argued and we reject what the district judge said. because we think the district judge meant something else.
Correct, I would agree with that. And I think the record itself also reads to say that that is not what the district court said or meant, because, and you look at that last statement.
It's just like the obliterated serial number, right? He's saying the guideline takes account an obliterated serial number.
Correct.
Right? The guideline doesn't take account that the gun was used in prior crimes. Now, we can reject that and say it's a factor that should not be considered, and then we would reverse. Or we could reverse, right? I mean, you're saying even if we reject it, we should not reverse, but we have to reject it.
Correct. I think you have to reject it, and I would go back to, in the record, there's 5 additional pages of the court highlighting that these priors, some are not accounted for, that the ones that are more extreme than what the guidelines given account for, and that is all. And the other reasons, that he had a good home life that many defendants don't, he took that as an aggravator. And all of those reasons were the reason for the 90-month sentence, not the ballistics report. Unless the court has any other questions, we would ask the court to affirm. Thank you.
Okay, thank you. Mr. Skaggs, we'll give you a minute on rebuttal.
I don't think we've ever heard from the government why the language about the ballistic report was put in the sentencing memo. You can make a lot of guesses because it doesn't make Tony Ross look good. But when all is said and done, it's unproven, uncharged conduct. Without any additional information, our position is that is unreliable to rely on. So that's all I have. We'd ask you to vacate the sentence.
Okay, thank you, Mr. Skaggs.
Thank you.
Okay, the case will be taken under advisement. Our last case today is United States versus Holder, appeal number 23-1426. Mr. Jungle, whenever you're ready.
May it please the court. My name is Dan Yangle, and I'm appointed counsel for Mr. Herbert Holder. This is an unusual sentencing appeal, mainly because at the sentencing hearing, both the government and the defense urged the court for a downward variance, and urged the court for a fairly significant downward variance. The bottom end of the guidelines in this particular case was 262 months as calculated by the court. The defense asked for 120 months and the government asked for a 180-month sentence. The court ended up sentencing the defendant to 240 months total. Our position is that the court committed procedural error in this case, and in turn, I'm going to address the procedural error first, and then I'd like to discuss the reasonableness of the sentence if I have time in the argument. In looking at the record, the court appeared, and the court stated there was a significant discussion between the judge and myself regarding an assault that the defendant had.
What 3553 factor does that affect?
I think that does go to the history and characteristics of the defendant, and I had mentioned that in the argument. And then I also do think it goes to an aspect of
So anybody
punishment.
that gets beat up in prison should receive a sentencing reduction because prison is a dangerous place.
I'm not saying that total, but I think that's a factor that the court has discretion to consider. What we do know is that many courts have considered the susceptibility to abuse in prison for child pornography type cases and other types of sex offense cases for individuals. I've had cases where I had an individual that was 5'2" and weighed 125 pounds, and the court found that that was a reason for a variance. So the danger and the assault are relevant to his history and characteristics.
Did the district judge here say, I can't consider it, or did the district judge say here, I'm just not persuaded that there's anywhere, I'm just not going to consider it?
Well, Your Honor, I would just reference a number of things in the record. Transcript, page 16, the court asked, like Judge Kirsch, you're asking me, is, what is it relevant to? And she said that she's not connecting it to, and then transcript 17, she's not connecting the dots to it being a mitigating factor. And then transcript 17 again, I'm not understanding.
But I'm not connecting the dots to it being a mitigating factor is different than saying I don't have the authority or the discretion to consider it.
Well, I think she implied that. She didn't say the word authority, but everything that she talked about when we were going back and forth is she continued to say, I don't get it. I don't understand how that links to sentencing. And
But doesn't she finally back off that at 18 in the sentencing transcript? First, she says exactly what you're saying. She says, if you're asking me to consider it, I'm asking you to articulate on what basis. And then she says it's not a basis for a variance. And if she hadn't said anything else, then I think we might be in the territory Judge Kirsch is talking about, where she might have potentially made a mistake refusing to consider something that she could. But then she starts to say it's not a 3553A, and then she backs up and she says, you said the nature and circumstances or history and characteristics is not part of his, well, I guess it's part of his history that he got these things. So she seems to kind of come around to realize that it's pertinent to history.
Well, I think she says, I guess, but the vast majority of the conversation is resistant, and she says multiple.
She says sort of lots of times. She says, I don't see which box this belongs in, and if it doesn't belong in any of the boxes, then it's just off the table.
Well, then is it relevant that the last thing she says is actually at the top of 19? So even after on 18, she says, I guess it's a part of history. She circles back to her original position. I still don't see the connection.
Correct. And I think that's her ultimate theme, and I think that's the procedural error that we have here. Clearly, she has discretion to evaluate this
But
factor.
why is that not connection to the relevance as opposed to correction, to, the authority to consider it? I mean, certainly, this is a very experienced district judge. Certainly, if a defendant came in and said, I'm suffering from a serious health condition and I may not be able to receive adequate treatment in prison, we can assume, as I would assume every district judge here would understand, that they have the scope and the authority to consider that as part of the defendant's history and characteristics. Here, she acknowledges it's part of the defendant's history and characteristics. Why are her statements just not, it's just not relevant here that he got beat up in prison? Prison is a dangerous place and these things happen.
But I think she comes back and even, sorry, I don't want to mispronounce her name, Your Honor, but even what the other judge pointed out was that she circles back to the same position, which is that it's not something that she is going to consider, and that she doesn't have the discretion to do it.
But that's what she says, right? No, it's not something I'm going to consider. Is different than I don't have the authority to consider it.
Let me ask you, if what Judge Kearse is saying could be a fair reading of this transcript. If we find that there are two fair readings of this transcript, what happens in the case of an ambiguity?
Well, Your Honor, I would think if there's any chance that the court believed that she didn't have discretion or authority to do something, the line of cases say that the case should be overturned. So the defendant has the right to a fair proceeding. He got a 20-year sentence. He was a Graham-level drug dealer, and when the government, is asking for like an 82-month variance in a non-cooperating case, that's unusual. And even in the record, the court said, "Well, I never hear the government making."
That's a substantive reasonableness issue.
Correct, but I think
which is tough in this case. I mean, he did get a departure, and we may disagree with the district judge did, but to say a below guideline sentence is substantively unreasonable, I don't think we've ever done that. Well, I don't know that any circuit has ever done that. I might be wrong, but I just don't know of any cases where that happens.
And I think that's a major concern when the Supreme Court lays out that the appellate court's obligation is to do a reasonableness assessment of district court sentences, and the court's never found ever a case to overturn. I think that's
below guideline. Below guideline sentence.
And I think but when the guidelines are so extreme in some of the basis that we have here, but back to the procedural point, which I think is our strongest argument to have the case overturned, is I think it's clear from the back and forth of the transcript that the judge is in a position where she doesn't believe that this is something that she can consider, and she continues to ask about the 3553A factor. She continues to ask how it's relevant to sentencing, and then she circles back to the position after the comment that you had talked about, Judge Kirsch. So I think the theme is that it's not something that she's going to consider, and then she doesn't raise it in her ultimate sentencing. Now, what the government has said that the government believes that we have waived this claim, but I disagree with that in this particular situation because we addressed this at length. Almost all of my sentencing argument was concerning this issue. We went back and forth on this issue, so I didn't circle back to that. But I think we have preserved that issue. And I think that issue is reversible. I think the government has waived any harmless error issue because they didn't raise that in their response, but I don't think it's harmless error in this particular situation. We have a judge that did grant a variance. So the judge granted a variance, and this information that she didn't believe was she could consider or that she had discretion to consider could have made a difference to make a lower sentence. So I'm going to reserve the time I have. Thank you.
Certainly. Mr. Bloodworth.
Thank you, Your Honor. May it please the court, Casey Bloodworth on behalf of the United States. The 240-month below guideline sentence that was imposed in this case for what the district court characterized as someone knee-deep in the distribution of drugs in a small community was both procedurally sound and substantively reasonable. Regarding the procedural claim made by Mr. Holder, I think the record in this case shows that the district court didn't outright reject the argument, but was just inviting a colloquy with Mr. Holder's counsel about how the district court should weigh
There's
that.
some concern that reading a district judge's questions to be ambiguous will invite district judges to not ask any questions at sentencing. This is a process, this is somewhat of an intimate process with the district judge trying to understand the nature of the argument so the district judge can deal with it. If we find ambiguity in everything that a district judge says or asks, sentencing hearings are going to be very short and sterile, is my guess.
I think Your Honor's point is well made, and that kind of ties into what my argument was. This was a back and forth.
But on the other hand, I mean, I'm troubled by a lot of things she says. It's not often that you see, given the breadth of the 3553A factors, that you see a district court saying, you're trying to argue something to me that is just not part of what I take into account. And she keeps saying, I'm not following you, I can't connect the dots, what are you talking about? And, you know, with perfect candor. And at one point she sort of tries on for size whether this is a factor relevant to history, but then, as Judge Jackson-Akumi points out, she backs off again. And if a district judge has taken something off the table that belonged there under the history and characteristics criterion, then there's potential error, even if it was a below guideline sentence. It's a procedural error. It's not a substantive error. I'm not going down the path of saying this is substantively unreasonable.
And I think that illustrates what, at least my view of the transcript and the colloquy between the district court and Mr. Holder's counsel was. It was an invitation on how to weigh this. I don't read it to be an outright rejection. I'm not going to consider that. There was a colloquy between
But it
them.
would have been perfectly fine if that's what she said, right? I'm not going to consider that is different than I can't or don't have the authority to consider that.
But if she says things that are equivalent to I can't or don't have the authority, and we read 3553A to show that she did have the authority, that's a mistake. That's a legal procedural mistake.
I think both of you are obviously correct, but I think the record in this case shows more of what Judge Kirsch is saying.
Well, no, it's not more of what I'm saying. It's just like the last case. We would have to reject what Judge Yandel said. We would have to flat out reject it by saying, you said I can consider it as part of its history, but you didn't mean that. You didn't know that. You said it, but you actually don't understand your authority.
Right.
After having sat in the district court for, I don't know, 15 years or 10 years, however long she's been there, even though you said this, we reject it.
Right, and it's that ambiguity that invites questions about that, and I think that illustrates your point further, that the colloquy that the district court was having with Mr. Holder was to not determine whether she had the authority to consider this. I don't see anything in the transcript.
If she didn't
that
have the
says-
authority, maybe she would have cut this short by just saying, "I can't consider this.
Right.
Move on." It's wait a minute. What fact
but-
he gets beat up in prison? How is that relevant to a sentencing reduction? It's not part of your history and characteristics. I mean, you have a hangnail. It's part of your history and characteristics. That's what she's saying. What difference does it make that you got beat up in prison here?
Well,
Why
that's
does that
right. She's-
justify
but-
a reduction?
And what does she mean when she says, I'm, quote, not connecting the dots between your assault and the 3553A factors? She's not saying, I think it's a strong factor or a weak factor. She's asking, is it even within the factors?
I certainly don't want to put words in the district court's mouth on what she meant when she said that, but the way I read it in context of everything else is trying first, candidly, I think she was trying to identify an applicable 3553A factor. But once that was done, I think the colloquy is, okay, how do I weigh this? And in Mr. Holder's brief and in his argument, he was basically using that as an example of the court should vary downward because this is illustrative of the harm that inmates face in a jail setting or in a prison setting, which is a generalized argument that every inmate faces. And as this court has said, a district court doesn't exactly have to specify and talk about a generalized argument that applies to everyone. And I think it's through that context and through the colloquy of what the district court had with Mr. Holder's counsel was trying to identify how to weigh this factor. And as was pointed out, she did consider it part of his history. I don't think she gave it much weight.
What
but I
do you
don't
make
think
of the
that's a
fact that she
procedural
comes
error.
back around and says, I still don't see the connection? Because here's an issue. Just as easily as she could have said, I don't have the authority to consider this, she could have also just as easily have said, I don't weigh that as significantly as you'd like me to weigh it. And she did neither.
And I think, and with the benefit of hindsight, we've probably all had occasions where we get to, well, I probably could have said that a little differently,
Right,
but I think
right.
you have to read it in the context of everything that was going on. And I don't see that as a full pullback of, okay, it doesn't apply to 3553A in any respect. The way I read it is what you've identified and how it applies to 3553A, I'm giving it very little weight.
So it sounds like you agree we have to interpret what she said, and you're just saying, your interpretation is the right one.
No, I think that falls back on what Judge Kirsch was talking about. You would have to reject what the district court said and impose a different meaning to what she said and say she didn't mean what she said.
I'm not sure that's right. I mean, she kind of, when does she actually say, I can consider this factor? Never. She thinks maybe history, and then she goes back and, maybe not.
And I think that goes more into how it's weighed,
No,
not
I don't
to
know.
what bucket it falls
we
in.
need to cross the first threshold first, that it's even in the game. And if she's said it's not, then we have a problem. If she when she mentions the word history, if that's to be understood as saying, well, it is a factor, but I'm just not impressed with it as a factor, that's her prerogative. She can certainly do that.
Right, and I believe that when the district court was saying it's irrelevant to whatever 3553A factor you've identified, I've identified, or we've all talked about, is illustrative to it just doesn't weigh much with respect to that particular 3553A ground. Not once did the district court say, I'm finding that this doesn't apply at all in any way, shape, or form to 3553A.
Yeah, what your argument is, we would have to find that the district court didn't understand that she had the authority to consider the history and characteristics of the defendant, that she totally doesn't understand 3553.
Well, I don't think it's that she didn't have the authority to consider an assault in the jail as part of history and characteristics. She knows she can do history and characteristics, but her jail assault's part of that.
And I think that falls on what Mr. Holder's main argument before this court is that it was a clear indication that the district court didn't believe she had the authority to consider that. And I don't think that's what the transcript
That's
shows.
his argument. It's
in
gotta be
any
because
way.
she says it's part of his history and characteristics.
And I don't think that the colloquy between the district court illustrates at all that she was confused about what the scope of her authority is. I think her ultimate sentence illustrates that she very well knows what her authority is, disagreeing with both parties, going through 3553A and imposing a sentence that's still below guidelines, but above what everybody
Certainly
recommended.
not with the first questions, right? Because the first questions are, how should I consider this? She could have asked, do I have the authority to consider this? How do I consider this? And defense counsel, whoever the defense counsel is, here's how you consider it's part of history and characteristics. The judge says, oh, I understand it's part of the history and characteristics. I reject it. Okay, that would be, I understand that I can consider it. Surely, what you had for breakfast is part of your history and characteristics. I can reject what you had for breakfast as a mitigating factor.
And rejecting it is synonymous to giving it no or little weight whatsoever, which the district court certainly has discretion and authority to do. And there's nothing in this transcript that indicates the district court didn't believe she had the authority to weigh it in one way versus the other. Moving on just very briefly to the substantive reasonableness, as you've indicated, there seems not to be any example of a below guideline sentence being reversed for not being substantively reasonable. The transcript shows a well-measured, well-calculated, well-thought-out application of 3553A, bringing in defense mitigation arguments in that, including, I think, this assault on the jail and imposing the sentence that the district court did. So we would ask this court to affirm the sentence below.
All right, thank you. Thank you, Mr. Bloodworth. Mr. Youngle.
Thank you, Your Honors. Just getting back to this context and this the debate that's going back and forth about the statements. Your Honor, the only thing that the judge talked about history and characteristics was her word was "I guess." Okay, a speculative type word, and then she circles back to the other statement that she doesn't.
Well, we're also reading a transcript here. We don't
can look
require precision. I mean, we would have to find that she didn't understand that she could consider the defendant's history and characteristics.
That's a broad scoped, that argument. No, we just have to. The procedural error here is she didn't consider this particular characteristic. She didn't think that this fell under those characteristics, and that's where she made the procedural error. So
what you're saying is she didn't think that this assault was part of the defendant's history and characteristics?
Because by using the word "I guess," that's speculating that that's what she thought. Everything else, the context says.
She's also asking you, how is this relevant? And she's trying to come up with ways in which it's relevant, I think.
Correct. And I think the first statement was I said history and characteristics, and I said punishment. And then I said it wasn't the biggest reason for a variance, but it was a reason for variance. And I think in the transcript it says that she couldn't see this, that this isn't a reason that she could do a variance. So that's where I think the disagreement is here. And I think the context is in favor of the appellant and the defendant in this case. And I appreciate the time. Thank you for allowing me to argue the case.
You're very welcome. Thank you. Thank you to both counsel. The case will be taken under advisement. The court will be in recess.